Court's back in session.
All right, I hear that, you guys can be seated. Thank you. That apparently inside my courtroom people are going to try to behave, but outside my courtroom people can't behave outside. If I have to have the entire courthouse full of deputies sitting there walking it outside my courtroom, I will.
We think we know who it is, and it's not somebody affiliated with either party who's out videotaping everybody.
It might be one of the sovereigns. We have a few that have nothing better to do than to hang out.
Yeah, we can identify the clothing of the female who was videotaping all, and we think that we weren't up there. We were down getting ready for what we're doing. But
just so you're aware, when we were leaving, Mr. Smith-Levin was walking with me, and the lady, she's wearing a black what's it?
It's a Tampa Bay Light
shirt, and she was basically, I mean, within arm's reach of me as we were walking by doing that, and I just ignored it.
What's her name out of jail? Christine Scott?
Scott. I don't think so, not yet.
Okay, so it's not her. I seem to attract these cases.
But Your Honor, that is exactly who I was referencing earlier. There's another individual who is commonly with Miss Scott. So the one that I mentioned, the sunglasses, it's a sovereign. So yes,
Okay.
you might be along the right path there.
Okay, so yeah, they've got nothing better to do than to create issues. All right, the guy with the sunglasses come off, they go into his pocket, or he does not come into the courtroom.
I didn't know.
I'm going to bring everybody in who is going to be watching the trial. They come in, everybody will be seated. Once they're in this courtroom and I start this trial, nobody leaves until I say I have a break. And then anybody outside who is not in here before I start this trial, they are not allowed to come in until I take a break.
Yes, sir.
Okay? And when I say take a break, that's me when I'm bringing the jury out, they have a break and I'm moving on to something else. Okay?
Yes, sir.
So, because I do not want this to turn into chaos. There's too many people, and I don't want them. They already did once when somebody walked in when I was reading instructions before we went to lunch, and 3 of the jurors were looking at the door. So I do not want that brought in here. So right now, State, you ready to proceed?
Yes, Your Honor.
Defense, you ready to proceed?
Yes, sir.
All right, make an announcement in the hall. Anyone who is, first thing I want is all the witnesses. I'm assuming you want to rule of sequestration. First, make an announcement. Anyone who is here to be a witness is to come into the courtroom.
I think they're in the side rooms already, right?
All right, they're all in the side room?
Yes, do you want them in the courtroom, Your Honor?
Bring them in so I can instruct them.
Have a seat, front row. These are the witnesses. Oh.
Okay. I got everybody here. All right, everybody who's in the courtroom here has been listed as a potential witness for today. The rule hasn't been invoked, which means that you cannot discuss this case amongst yourselves, either before you testify or after you testify. So when you get done testifying, you are not to converse with anyone about what you testified about, and before you testify, you are not to converse with anyone about what you're going to testify to. Everybody clear? Everybody understand? Okay. I'm going to have you step out and go wherever it was that you were seated, and then deputies, once they're out, down the halls, that anybody who's going to be here to watch the trial must come into the trial right now and be seated quietly.
Yes, Your Honor.
All right. Thank you all. Members of the jury, ladies, clerk, do not let me forget to swear in the jury, okay? Sorry. And deputies here are really out. So, Michael, you can tell you where number 1 is.
Deputy Michael? Yes.
Which one's number 1?
Three.
Are you sitting here? 1, 2, 3, 4, 5, 6, 7, 8.
Did you give it back to me?
See a lot of open bottles. Please do not drink while it's open in the courtroom. Make sure all electronic devices are turned off and put away. That's watches, glasses, or anything like that.
No.
Phones. There's no recording to be done in the courtroom.
All right, ladies and gentlemen, I made it clear before, I'm not sure if all of you were in here when I talked to everybody before the trial began. I'm going to reiterate the fact that I am not going to tolerate any noise. I'm not going to tolerate any confusion. I'm not going to tolerate anybody's face making any type of facial expressions and any type of disruption of this courtroom during this trial. To me, this is a battery trial. These 7 people are spending their day in this courtroom to listen to facts about whether a battery occurred. You all are not going to do anything that affects my trial and causes any type of issue that might mistry it. Anyone who has a phone, they better be off, not on silent, not on vibrate. They are to be in a purse, a pocket, a bag, someplace where I don't see it. If myself or a deputy sees any phone, the presumption is that you are recording, and I will take your phone, and then I will begin proceedings for violation of the court's orders and potential contempt of court, which direct contempt of court can place you in jail. So while your friend might be found not guilty, you could be sitting in jail up to 6 months. Is everybody absolutely clear?
Yes.
There are a lot of you in this courtroom, so you are in here until I take a formal break when that jury gets out of the courtroom. There will be no walking in and out of my courtroom while I am in session. Everybody understand?
Yes,
Hope
yes.
everybody went to the bathroom. Understand, I am a judge that does not tolerate nonsense, and I will not tolerate any nonsense during the course of this trial today. Is everyone absolutely clear?
Yes, Your Honor.
I don't want to see a twitch on anyone's face. You may bring the jury in.
Yes, Your Honor. Might continue and get lined up for there.
Those notepads are in the mirror for a second.
That's wrong.
All right. Whoever's leaning over there, laying over, sit up straight, please. Yes, you.
Oh, I'm sorry.
Sit up straight.
I'm sorry?
Sit up.
Oh, yes, ma'am, I'm sorry.
What? So, for example, a line there, go ahead, turn them in. Sure, the rest of them.
Okay. Stay standing because you're going to get sworn in.
Go ahead and have a seat.
No, I told them to stay
Oh,
standing.
sorry.
We're about ready to swear them in.
Oh, fine.
It's all good. All right, everybody's present in the courtroom. Raise your
Yes.
right hand, please, and be sworn in.
Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant and render a true verdict according to the law and evidence, so help you God?
Everybody be seated, please. All right, ladies and gentlemen, you may have noticed that you have had a paper and a pen. I need to give you an instruction on that before you start writing anything. The first thing is, at the end of this trial, it is my responsibility to take your notes out of that pad and put them in a shredder. I have no interest in what your notes say. So what I want you to do is, after you open that cardboard card, that first page, write nothing on that first piece of paper. Okay, that first piece of paper, do not write anything on it. Just flip it over. Because when I open up the cardboard, I want to see a blank piece of paper. At the end of the trial, I'll leaf through the bottom till I don't see writing anymore. I'll take a couple of extra sheets so that there's no indentations, and I'll rip them out and I will stick them directly in the shredder. And you're doing me a favor by not putting anything on that front page. Okay? Now, if you would like to take notes during the trial, you may do so, but on the other hand, you are not required to take notes if you do not want to. That's left up to you individually. If you take notes, do not get so involved in your note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. State, are you ready for opening statements?
Yes, Your Honor.
You may proceed, Ms. Mead.
May it please court,
Yes.
counsel, members of the jury. We are here today because on July 29th, this defendant, seated right here, let his emotions get the best of him. Now let me take you back to July 29th of 2025. This defendant was protesting outside a building owned by the Church of Scientology located in downtown Clearwater. This defendant, along with two other individuals, were using chalk on a mosaic located just in front of the building. They were spreading it around, writing words, doing their thing. And in response, 4 members of the Church of Scientology exited the building in order to wash away the chalk that was being thrown around. They came out of the building, used water buckets, and they were cleaning off the mosaic. And that is when this defendant let his emotions get the best of him. One of those individuals is named Mr. John Gaffney. Mr. Gaffney came out of the building, walked down the steps, and began to use that bucket of water to wash away the chalk. This defendant walks towards Mr. Gaffney, and out of a reaction, throws a bag of powder, bright blue powder, directly on Mr. Gaffney. All while saying, "Here you go." It is because of this defendant's actions that we, as the state of Florida, have brought the charge. We have charged this defendant with battery. And because we brought the charge, we bear the burden in this case. And that burden is to prove all elements of the charge beyond a reasonable doubt. And members of the jury, I have no doubt that we will do that here today. Today, you will have the opportunity to see the events as they unfolded that day. In fact, it was captured on surveillance video. And you'll get to watch that surveillance video right here on that TV. Additionally, you will hear testimony from this witness stand. We'll call several witnesses, and they'll tell you what happened that day. You'll hear from Mr. John Gaffney. You'll hear from 2 other members from the Church of Scientology who were also participating in the washing away of the chalk. You'll hear from officers who conducted the investigation. You'll also hear from a detective who also participated in that investigation. Towards the end of the trial, Judge Hessender will instruct you on the law. And at that time, she will remind you that a battery is any unwanted touching. It does not need to be person-to-person contact. Instead, making contact with another individual with an item is sufficient. And members of the jury, that is exactly what happened on July 29th. Members of the jury, at the close of this trial, Mr. Lechner will come before you, and he'll make a closing statement, or have his closing argument. And at that time, he will ask that you return the only verdict that is supported by the facts, the law, and your own common sense. A verdict finding Mr. Aaron Smith-Levin guilty. Thank you.
Will the defense be doing a opening statement?
We will, Your Honor.
All right.
May I please report?
Yes, Mr. Perlman?
Counsel? Yes, Your Honor. Members of the jury, there were some facts that might have just been left out of that rendition of what occurred on this day in July of 2025. To say it's right, there's video of all of this, and that's the beauty. You don't really have to take anyone's word other than the objective evidence and the testimony. You'll weigh it as you find it to be credible or not. The video will, as I've said, speak for itself. This is self-defense. And what the state left out of their rendition of the facts that we believe the evidence is going to show you today is that my client was there demonstrating. He was there protesting the Church of Scientology, something he'd been doing for 10 years, along with 2 other friends and compatriots of his that have been doing this for a very long time. They were there to demonstrate. They were there doing chalking and cornstarch on the ground, putting messages that they felt strongly about the Church of Scientology and were not for it. And putting numbers down for members to call if they wanted help, things of that nature. They were putting this all on the ground in a public area that they were constitutionally allowed to be in and to protest it. Not private property. It was very clear. In fact, on the video, you see the sign where, it's not there yet. You will. You'll see the sign where it says, trespassing beyond this point. My clients never went onto private property, to the Church of Scientology's property. They stay where they know they can be, where they've demonstrated many, many times. What the state left out is that prior to this incident occurring, the members of the Church of Scientology came out and they were dumping water down these stairs as kind of the cutoff onto the demonstration, onto the chalk, onto the cornstarch, onto my client, and onto his friends. Then the first round was very hot water, and they dump it on down. And you'll see it's all wet and soaked because this is the day that, one of the days that the members of the Church of Scientology wanted to make a point about how they felt about what was being written, again, in a constitutionally protected demonstration. This goes on first, and then the second round, and you're going to see it. I mean, they're big buckets. At one point, they're bringing out barrels, like not barrels, but large containers. You've got to wheel out. They're on wheels, and they're really heavy full of water, just dumping them down onto. And again, the first round, hot water, heated up to the point where it was painful. Second round comes, same thing. Third round comes, and at this point, and again, you'll hear the evidence. My client, the others try to engage, like, can you stop this? Why are you doing this? No response, no engagement, won't engage, won't say anything to him, just dumping water. Again, as the state just said, a battery is any unwanted contact, including an item. That's sufficient for battery. What we believe the evidence will show you is, in fact, that my client was, in fact, the victim of battery, as were others, but that's not the point right now. He's the one on trial. We believe when you see the video, the part that is left out of this is when one of the members, the listed victim in this case, goes down the stairs. It goes down the stairs intentionally. You'll see on that video my client standing there with cornstarch in his hand. He had the cornstarch in his hand. It was part of what they were dealing with, what they were doing. And he sees him start to come down, just throw more water on different areas that they hadn't gotten with all the gallons and gallons they've been dumping on everybody earlier. My client goes to step in the area again where he's allowed to be. The member of the Church of Scientology won't stop. My client stands there and he says something in the fact of, you want to do this, don't do this. You'll hear, the testimony will play out what was said at that point. And the member of Scientology throws the water onto my client, at which point he has the bag of cornstarch and throws the cornstarch in the direction of the back. This is the back. This is why we're here. Self-defense was a word we used in word hire. You're allowed to defend yourself against unlawful touching. You're allowed to put yourself in a position where you don't have to be the victim of somebody else's unwanted touching. Throwing water on someone is a battery. Defending yourself against that when you're demonstrating your constitutionally protected right and area to do so. That's what this case boils down to. It's not up to the state. This case will come down to you. Once you've seen the videos, and whether you believe the battery component of this or not, the bottom line is my client has a right to protect himself. This is a non-lethal scenario. He is allowed to use non-lethal force. It was the cornstarch powder after being dumped with water over and over and over. It's not complicated. This will not be a long trial. Wait to see the evidence. Wait to see the evidence. You'll make your own decisions. The law will be given to you. The judge will instruct you on what self-defense is. She'll also instruct you on what battery is. You can determine whether my client was the victim of the battery that day or not, and you can determine whether you acted in self-defense. You'll hear from our witnesses as well. Ms. Fullerton in particular, she's who we're going to be calling. She's going to tell you exactly what happened, why it happened, what they were doing, why they were in fear of the water, especially how hot it was, and why my client was in fear as well. You'll hear all of this. At the end of the day, it's not up to them, it's not up to us. It will be up to you to make a lawful verdict or come to a lawful verdict in this case. And we will ask you find my client not guilty of battery because by law he is not. Thank you for your attention.
State, call your first witness.
Yes, Your Honor, the state of Florida calls John Gaffney to the stand.
Senator, next week, please.
Yes, sir.
Turn to Ms. Kirk, raise your right hand, receive the oath, answer loud and clear, I do.
Okay.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Have a seat over here. Adjust the mic, speak in a loud, clear voice.
And Ms. Me?
Thank you, Your Honor. Good afternoon.
Good afternoon.
Can you please turn and introduce yourself to the members of the jury, spelling both your first and last name for the record?
Yes, I can. My name is John Gaffney, John-Gaffney.
And Mr. Gaffney, I always like to start out by reminding you that although I'm the one asking the questions, I encourage you to speak to the jury because they're the ones that this is important to, okay?
Understood.
So, Mr. Gaffney, where do you work?
I work at the Church of Scientology in Clearwater, Florida.
And how long have you worked there?
I've worked there since December 2009. So this is my 17th year, 16th, 17th year.
And how long have you been a member of the Church of Scientology?
Since I was 18 years old. This is my 21st year.
On July 29th, 2025, were you working?
Yes, I was.
At what location were you working that day?
I was working at the main church building, 215 South Fort Harrison Avenue, downtown Clearwater.
And just to be specific for the members of the jury, what is your role at the Church of Scientology?
I'm a security guard for the church.
Okay. And can you please tell the members of the jury, and where is that location specifically located? I'm not sure, I might have missed it. Where is that located?
Well, that day that I was working, I was at the main church building, 215 South Fort Harrison Avenue.
Okay.
Otherwise, I work at many locations down there.
Okay. And on July 29th, that location you just mentioned, I just want to be clear, is that in Pinellas County?
Yes, it is.
Okay. Now, can you turn and tell the members of the jury what specifically happened that day?
On that day, I was working my usual security functions. That entails protecting the property, protecting the parishioners. There was a protest that was occurring outside our doors, out on the sidewalk, on the mosaic, which is outside. There was powder and chalk being spread out on that mosaic, and we were acting to protect our property.
Okay. And were you working with any other individuals that day?
Yes, I was.
Okay, and what are their names?
Nathan Mezentsev, Mateo Medaski.
Okay. And you mentioned that you reacted to protect the property. What exactly does that mean? Can you tell the members of the jury?
Yes, I can. On the mosaic, which is comprised of thousands of little stones and marble, there was different dyed chalks and powder being placed on that. We obviously wanted to protect that and make sure it wasn't damaged, so we were putting water down to wash away the powder and things that were being put down on it.
And would this be part of your role as a security officer for the church?
To protect the property, yes.
Okay. And did you ever come into any physical contact with the people that were conducting this protest?
No physical contact.
Okay. Now, Mr. Gaffney, does the building that you were located at that day working at and where the protest was occurring outside of, does that have surveillance in effect?
Yes, it does.
Were those cameras active and working on July 29th?
They were.
Okay. And was this particular incident that you just spoke of captured on that surveillance video?
Yes, it was.
Would you recognize that surveillance video if I showed it to you?
I would.
Permission to approach the clerk?
Yes.
I'm retrieving what has been pre-marked as States Exhibit 1. I'm showing defense, States 1.
No objection, Your Honor.
May I approach the witness?
Yes.
Mr. Gaffney, do you recognize that CD?
I do.
And how do you recognize it?
That is a CD that has one of the videos that displayed the incident.
Okay. And did we review that before coming to court today?
We did.
Did you sign it?
I did.
Is your signature on there?
Yes, it is.
Okay. And that's the signature that's located on the back of the disc.
Yes, it is. The top corner here.
And in that video, does it fairly and accurately depict the events that took place on July 29, 2025?
Yes, it does.
Your Honor, at this time, the state seeks to offer to evidence what has been pre-marked as States 1 and States 1.
Any objections?
No objection.
So admitted as State Exhibit number 1.
Permission to publish?
Yes.
Jamie.
I got you, by the way.
Let's get ready to party, baby. Come on, bring it. Bring it. Bring it. Oh, it's just gonna hit our water barrier, you losers. Yeah. Here you go.
I got everybody in it, by the way.
Yeah. Come on, bring it back. Come on back, baby. What? Did you want some more? Come on, we can play. Did you want some more, buddy? Come on, let's go. We can play. We can play. Let's go. Come on, we can play.
Mr. Gaffney, do you recognize the voice in that video?
I do.
How do you recognize it?
That is the voice of a person that has protested many times before. His name is Aaron Smith-Levin.
Okay. And did you have an opportunity to view another video from a different angle?
Yes, I did.
And would you recognize that if I showed it to you here today?
I would.
Permission to approach the clerk?
Yes.
I'm retrieving what has been pre-marked as State's Exhibit 2. Showing defense States 2. Permission to approach the witness?
Yes.
Mr. Gaffney, do you recognize that disc?
I do.
And how do you recognize it?
I reviewed that disc as well.
Okay. And did you sign it as well?
I did.
And provide a date on there?
I did. Today's date.
Okay.
My signature at the top.
And are the events portrayed in that video fair and accurate depictions of the events that took place on July 29th?
Yes, they are.
Your Honor, at this time, the state offers in evidence what has been pre-marked as States 2 as States 2.
Is any objection?
No.
State Exhibit number 2, so admitted.
Permission to publish?
Yes.
And Mr. Gaffney, I just want to be very clear for the record as well as for the members of the jury. Can you state who you are in that video just by referring back to it slightly?
I absolutely can.
Okay. I'm just going to have you indicate on there when it's pulled up. I'll just have you indicate and then I'll speak to it so that the record reflects correctly what you're showing.
Okay, good.
Oh, it's okay. Keep. Okay, so are you the second individual from the left-hand side of the screen?
Yes.
Okay, and are you carrying a white bucket in that where you just indicated?
Yes, I am.
Okay. And can you explain to the members of the jury exactly what you were doing there at the end when you walked towards the steps?
Yes. After the big buckets were dumped down to cover the majority of the mosaic, there was still some on the side, so I went over to that side part to dump more water down to wash away that part of the dyed chalk that was down on the ground.
At any point were you throwing water at Mr. Smith-Levin?
Never.
Were you only throwing water at the ground?
Yes.
And obviously we saw a big cloud of powder. Did that powder make physical contact with you?
It did.
As a result of that contact, were you ultimately checked out by medical personnel?
I was.
And can you tell this jury here what symptoms you were experiencing as a result of that contact?
As a result of that contact, I had irritation in my eyes, as well as irritation in my breathing, respiratory irritation. We were checked out for that.
Okay, so were you ultimately transported to the hospital as a result of this incident?
I was.
Mr. Gaffney, is the man who threw the chalk at you in this courtroom here today?
Yes, he is.
Can you please point him out and identify him by an article of clothing he is wearing?
Yes, he's wearing a gold tie in between the two men in the front here.
Your Honor, let the record reflect that the witness has identified the defendant.
Record so reflect.
A moment to confer.
Yes.
Mr. Gaffney, just to tie up one loose end, I just want to make sure, I know we mentioned that this would be something that would fall in your role as a security guard. I just want to clarify, was maintaining the mosaic itself one of your requirements of your role?
Yes, absolutely.
Nothing further, Your Honor.
Any cross-examination by the defense?
Yes, Your Honor.
All right, Mr. Perlman?
Afternoon, sir.
Good afternoon.
So, just to be clear, you had to go to the hospital because the cornstarch irritated your breathing respiratory system, you said?
Eyes.
Okay.
And the respiratory system. Yes.
Okay. You were wearing a mask, though, right? I mean, you're clearly in the video wearing a mask, and it still somehow irritated you?
I felt it, yes.
Okay. So you then go to the hospital, or released from the hospital? Okay. Now I want to talk to you just briefly about the concept of protecting the property. You were assigned to protect the property, and I just want to be clear, from chalk and cornstarch. That was what you were protecting the property from, essentially?
From damage.
Damage. From, again, what you clearly saw, because they had been out there for hours, and you guys have been watching and doing what you had done for hours. You clearly saw it was chalk and cornstarch, right?
No.
You didn't know what it was?
No.
So you just thought water would get rid of what? Paint? Long-term damage? What did you think the water was going to clear up?
Potentially. Long-term damage.
Well, the thing is, that was your third round of dumping water onto the chalk and the people out there, correct?
No.
No?
Not correct. We weren't dumping chalk or water onto the people out there.
I apologize. Dumping water down into the area where the
Onto
chalk
the
was and the
mosaic.
people were.
Yes.
Right, which is where they were protesting, right?
It was onto the mosaic to protect the mosaic.
Right, where my client and other people were also at, right?
Mm-hmm.
So you're dumping water into the location they also were standing, right? Mm-hmm. Is that a yes?
Yes.
Sorry, I've got to do that. I don't mean to be annoying about that, it's just for the record. So you're dumping water on them. That was the third round of you guys dumping water down into that area where they happen to be standing, right?
Not sure if that was the third round, but
You'd done at least one, if not two more before that?
at least one.
Okay. And so I guess my point is, it's clear after round one, and you're not sure if there's a round two or not, that it's chalk and cornstarch.
It's not clear if that's chalk and cornstarch. It is powder, yes. It is dyed, yes.
And it clearly, once the water hits, it just runs off.
Some
right?
of it, yes. Some of it did not.
Like the chalk, I guess, was a little more difficult, right?
Possibly.
Okay. And so you're protecting the property from this chalk and cornstarch. And instead of just waiting for them to be done protesting or anything of that nature, you guys decide you're going to hit this head on while they're still there protesting, right?
It was to lessen the problem of having the dye and everything sit on the mosaic for an extended period of time, yes.
Right. Yeah, I know you keep saying dye. There was nothing that was dyed. There was no damage to that mosaic. Correct?
No?
Correct. And so there was nothing to lessen. Again,
No, that was not correct.
Oh, it's not correct?
No.
There was damage to that mosaic.
Yeah.
Okay. Today, now, there's damage to the mosaic from the cornstarch and the chalk. You're sitting here saying, I got to protect the property. Was there damage to it from the cornstarch and the chalk or not?
There was dye on the mosaic, and that's what I was removing from it. That's all.
Okay, and you keep saying dye. Do you have any idea if it was actually dye?
Well, it was colored.
Okay. So, long story short again, it's all running off from the first round, 2 rounds of the water being thrown onto it. But you guys, again, wanted to hit this head on while the protesters were still there protesting Scientology, correct?
That's correct.
Right. And the bottom line is you didn't like what they were writing, correct?
No.
You didn't like they were saying detrimental things about the Church of Scientology on their chalk and on their cornstarch and on their writings around.
What they were saying has nothing to do with why we're putting it down.
You just said...
Of course I do not agree, but that's their right.
Right, so if they were saying, we love Scientology, we're big fans, and we want to promote it, and wrote that, you guys would have hit them with 3 rounds of water dumped onto it, right?
To protect the property, absolutely.
Sure. Okay. And so, in this situation, though, it was negative, and you didn't like it, although that had nothing, as you're now saying, to do with any of it, right?
That's correct.
Okay. And so, when you walk out...
I didn't, to be clear, I did not know what they had written there. I wasn't out there looking at it. I saw them putting chalk down, and we were putting water down to wash that chalk away.
You didn't see the word cult?
No.
No. You didn't see call for help with a number?
No.
I mean, you didn't see any of that?
No.
Okay.
Not until afterward.
So on any of the 3 visits out, you didn't look once at what was put down there, right?
No.
And so the last video that we saw, which is a perspective of you and your fellow security members going outside, you see the 2 big bins of water, and you've got the bucket at that point, right?
Correct. I do.
Now, everyone else stays up on the stairs because there's a sign right there saying no trespassing past that point, correct?
There were multiple signs.
Right.
There was signs at the bottom of the stairs, there were signs at the beginning of the mosaic,
right,
and there were signs at the top of the stairs.
And they're allowed to be protesting where they are at.
That's correct.
That's correct. And so you all stay at the top of the stairs and you dump that water down, but you then decide to go down, correct?
Yes.
Now, we saw the first video, and Mr. Smith is standing there, and he's got cornstarch, and he's like, you want to do this? You saw it. You heard what was said, correct?
Mm-hmm.
You hear it, right?
Not when I came out. He didn't say anything to me when I came out.
When you come down, though, with the bucket.
No, he didn't say anything to me until afterward. I didn't hear any of his communication until after.
So you don't hear
Until he
anything
threw
he's
the bag
saying.
of powder on me.
You don't hear anything he's saying as you walk towards him.
I didn't walk towards him. I walked to the bottom of the stairs to hit that bottom patch next to the mosaic, and that's what I explained.
I know that's what you explained, but the bottom line is he is clearly walking towards you, correct?
After I started walking down the stairs, yes.
Right, and he stops. And
He approached me as I walked down.
And you don't stop.
I stopped at the bottom of the stairs.
Right. And that's when you throw the water, correct?
I threw the water. He approached me as I was throwing the water.
Well, the video speaks for itself, correct?
Absolutely.
Right. And you'd agree that the water got onto him? Nope.
No, the water was not thrown onto him.
Just hit him after it hits the pavement?
I can't speak for if it... I did not see it hit him. It was thrown onto the ground.
Right. Is that because you refuse to look at him? You're just trying to throw that water, just not engaging with him standing right in front of you?
I was not going to engage with him. I had no intention to engage with him.
Right.
My only intention was to protect the property. And I put that water down onto the pavement next to the mosaic, And that's all I did.
So this wasn't a slow, methodical escalation that you guys are doing through the last 45 minutes to an hour before this all takes place?
Not at all, sir.
Not at all. And so, after the first round of water, and then the second round of water, and then this time you actually go down this time to where he is at, correct?
Not to where he was at. He was roughly 15 feet away from me, and I walked down to the corner, actually away from him. He approached me as I walked down the stairs.
Right. And it was very clear at that point, you said you didn't hear anything that he said to you. You just throw the water in again. Whatever the video shows, it shows, right? Correct?
That's right.
Okay. And at no point were you angry or frustrated with him, right?
No.
Nope. You didn't
After
know?
getting the chalk in my face, that was a little bit... I didn't feel very happy about that. I think anybody would understand after you get something like that put all over you, you wouldn't feel very good, but that was about it.
Sure. I'm going to assume that they were probably not happy having water dumped on them for the better part of an hour either, right? So, this was clearly a scenario where you were adverse to each other. You agree with that, right? Nope, no. You didn't care. You were just doing your job,
We
right?
were just protecting the property.
And so after you specifically walked down the stairs on this particular time, and why not just step back? Why not just wait?
Because there was still more in that area, and I was protecting that area.
And you were not going to wait. You were going to engage with that right then and there to protect the area from the cornstarch, right?
Yeah.
Just one moment here. Now, it's your testimony, just to be clear, that you hadn't been out there and you didn't look at anything that had been written down, right? Is that correct?
I did not say that I hadn't been out there. I said that I did not read what they had written.
You were selectively able to not understand the letters if they're put out in an order.
I was simply going out there and washing the dyed chalk off the mosaic.
Okay. You have permission to approach. I'm going to show what we have pre-marked as defense 1.
No objection, Your Honor.
All right.
So just to be clear, again, it's your testimony. You didn't see, what was that? You went out there, but you didn't see anything that had been written down. You were just trying to clean things off, right?
That's right.
Now, this I'm actually showing to you, this was prior to this final incident that was videotaped, right? Correct?
That's correct.
Right. So you didn't see this giant word of cult right here?
I did not, because I didn't go down there.
Okay.
I did not walk past them.
And you didn't see any of the other letters or verbiage that was written before you guys dumped all the water onto everything?
No, sir.
You have permission to introduce, well, let me ask this. Is this a fair and accurate representation of you being down there, let's say 20 minutes before this video took place?
Yes.
Okay. And that looks accurate to the best of your recollection of that incident?
Yes.
Permission to introduce what is previously marked as defense 1?
Any objection?
No objection, Your Honor.
All right, so admit it as defense 1.
Yeah, we'll have to do 3. Yeah. Defense 3. Okay. No, I apologize. I mislabeled. I thought this was 1. We got 3. We'll introduce. I'll publish this at a later point. I apologize for mislabeling the evidence. So it would be defense. We'll have it pre-marked as 3, and we'd have to have it introduced as 3.
All right, defense exhibit number 3, so admit it.
You said you knew Mr. Smith-Levin, correct?
I do not know him.
You know of him.
Yes.
Okay. You've known of him for quite a long time.
A little while.
And just to be clear, you knew it was him out there during this protest, correct?
I did.
Right. You knew it was him, and you had no problem going down to the location he was at in that moment, correct?
To protect the mosaic? No.
Nothing further, Your Honor.
Any redirect?
Yes, Your Honor. Mr. Gaffney, I'm going to ask you a few questions to go through some of the things that were addressed on cross-examination. It may seem like I'm bouncing around, but in reality, I'm just hitting the topics that were addressed.
Yes.
So I first want to ask, were your eyes protected at all on this day
My eyes were not protected.
Okay. Was the mask simply covering your mouth?
It was simply covering my mouth.
Okay. Another question I want to ask you is, did you at any point dump water on the protesters?
Never.
Did you dump water on Mr. Smith-Levin?
Never.
Where did you dump water?
Onto the ground.
Now, there was another point made about why didn't you just sit back and wait until they were done what they were doing and then act? Do you have any obligation to wait for actions such as that before taking your action to uphold your duty as a security officer?
No.
Were you simply fulfilling your role as a security officer that day?
Absolutely.
Now, I want to go through that video one more time with you because there were points made about the video without showing the video, so I want to go back through it one more time.
Okay.
You're under permission to publish States 1.
Yes.
Jamie,
I got you, by the way.
let's get ready to party, baby. Come on, bring it. Bring it.
Okay, at this point, where are you located?
I'm located right there.
Okay, so third, what is it? Third from the left, top of the screen, top of the steps.
That's correct.
Okay, and where is Mr. Smith-Levin located?
Mr. Smith-Levin is located right here.
If you could approximate about how far feet-wise, what would you say he's at right there?
20, 25 feet.
Okay. Would you say about this distance is fair?
Yeah,
Okay, so I'm standing right behind the podium and you're at the stand.
that's correct.
Okay.
Bring it. Oh, it's just gonna hit our water barrier, you losers. Yeah. Here you go.
Okay, at that point, where are you located?
Right at the bottom of the stairs,
Okay.
behind our property line.
Had you just come down the steps?
Yes.
Did you come down the steps prior to Mr. Smith-Levin walking towards you?
Yes.
I got everybody in it, by the way.
Yeah. Come on, bring it back. Come on back, baby. What? Did you want some more? Come on, we can play. Did you want some more, buddy? Come on, let's go. We can play. We can play. Let's go. Come on, we can play.
Okay, and just to be abundantly clear, are you approaching the defendant?
Never.
Is the defendant approaching you?
Yes.
A moment to confer.
Yes.
Nothing further, Your Honor.
May this witness be excused?
We ask you to remain on standby, Your Honor.
I am informed to advise you that you can step down, do not discuss your testimony with anyone, but do not leave the building.
Yes, Your Honor.
Thank you. State, call your next witness.
Yes, Your Honor. The people of the state of Florida call Mateo Madashi to the stand.
I'm sorry, what was the name again?
Mateo Madashi.
Just go see my partner out there and we'll go just one. Stand right here next to me, please.
Get ready to pop.
Okay, turn face the clerk, raise your right hand, say the oath, answer loud and clear, I do.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do. Okay, have a seat over here. Adjust the mic. Speak it loud for the voice.
All right, Mr. Lechner, will you be doing the direct?
Yes, Your Honor.
All right, you may proceed.
Afternoon, Mr. Madashi.
Good afternoon.
Go ahead and introduce yourself to us.
My name is Matteo Madaski, and I work for the church.
Could you spell that for the court reporter?
Matteo is Matteo, and Madaski is Madashi.
Okay, and you said you worked for the church. How long have you worked there?
Since 2004.
Okay. Now, Mr. Madashi, I just want to get right to the point. So I want to direct your attention to July 29th, 2025. Were you present at the Church of Scientology that day?
Yes, I was.
What building were you present at?
The main church building.
And what's the address of that building?
215 South Fort Harrison.
Is that the flag building?
Yes, it is.
All right. And who else was at the flag building outside that day? Do you know?
John Gaffney, Nathan Mezentzev, and Dmitry Zenchenko.
And was there anyone on the sidewalk in front of that building?
We had several people protesting.
Okay. And where were you in relation to the protesters?
I was about 25, 30 feet away.
All right. And why were you in that specific location?
I was pouring down water on the mosaic to make sure it didn't get damaged.
Okay. Now, at any point during that day, did you see an incident happen between someone with blue powder putting it on another person?
Yes, I did.
All right. And do you see the person who threw that powder in the courtroom here today?
I do.
Could you please point him out and identify him by an article of clothing?
It's that guy with the gray suit.
Your Honor, let the record reflect the witness has positively identified the defendant.
Yes, so did.
What did you see this man do?
He approached John Gaffney with a big bag full of blue powder, and he threw it at him.
Were you able to clearly see that from where you were standing?
Yes, I did.
And would you recognize a video of that incident?
Yeah.
All right. Your Honor, permission to publish with authority and evidence at stage 1?
Yes.
Ready to party, baby? Come on, bring it.
Mr. Madashi, where are you standing in this still image?
I'm the last guy to the right.
All the way to the right?
Yeah.
Are you behind one of those black bin looking things? Okay. And is anyone carrying an individual, I know it might be hard to see, but is anyone carrying an individual bucket?
John Gaffney.
Okay, and where is he located?
He's in the center with the blue tie and white shirt.
All right, and are you all working together here?
Yeah.
So what was the purpose of bringing the water out?
To prevent the mosaic from getting damaged.
Okay. And go ahead.
Bring it. Oh, it's just going to hit our water barrier, you losers. Yeah. Here you go.
I got everybody in it, by the way.
Yeah. Come on, bring it back. Come on back, baby. What? Did you want some more? Come on, we can play. Did you want some more, buddy? Come on, let's go. We can play. We can play. Let's go. Come on, we can play.
Mr. Madashi, you mentioned Mr. Gaffney a couple times. When Mr. Gaffney walks down those stairs, what does he do?
He goes to the side and then pour water on the floor, close to the bushes.
And could you see that clearly from where you were standing?
Yeah, I did.
And did anyone approach Mr. Gaffney as he did that?
Smith-Levin did.
All right. And is that the defendant?
Yes.
All right. And after that occurred, did you see any type of blue staining on Mr. Gaffney?
He had a lot of powder all over his body.
When you say all over his body, can you describe where?
Like on his head, on his shirt, on his pants, shoes.
Was it on his back as well?
Yeah.
Moment to confer.
Yes.
Mr. Madashi, what exactly do you do with the Church of Scientology?
I work in security, so I make sure the people and the property is safe.
Are you also responsible for maintaining the property?
Yes.
No further questions.
Any cross-examination?
Yes, Your Honor.
Mr. Theophilopoulos?
Good afternoon, Mr. Mandashi. How are you, sir?
I'm good, thank you.
Mr. Mandashi, you indicated that you are in charge, or one of the people in charge of security.
I work in security, I'm not the in charge.
And you testified that you are to make sure people are secure, correct?
Safe.
And that the property is also safe, correct?
Yes.
And there's also a maintenance personnel with the flag crew, correct?
He was there, yes.
And the maintenance personnel with the flag crew is responsible for cleaning up the grounds, correct?
For maintenance of the building, yes.
And the exterior grounds, correct?
Also, yes.
Not security. You're supposed to make the property safe for individuals and to protect the individuals, correct?
The people and the property.
But as far as cleaning the actual grounds, I believe you just testified the maintenance personnel with the flag crew is responsible directly for that, correct?
He's also responsible.
Also, that is their job, correct?
It is.
And the reason security came out there was a show of force, correct?
No. I made sure the mosaic was not getting damaged.
Let's talk about the mosaic. That mosaic is on the property of the city of Clearwater, correct?
Partially.
About half of it, correct?
About half.
And, Your Honor, I move to introduce Defense Exhibit 2. I know it's out of order, but it'll assist in this cross-examination.
Any objections from the state?
Just lack of foundation as to with this witness.
Is this the one that I took
Judicial notice from the property appraiser.
You need to set a foundation that he recognizes it.
May I approach?
Yes.
Do you recognize what has been marked as Defense Exhibit 2? In particular...
Can you phrase in a different way?
Sure. Do you recognize what building this is in the red?
That is the flag building.
And what is this area at the top left corner of the Defense Exhibit 2 photograph?
That's where the mosaic and the sidewalk is.
And you would agree with me that the property line goes right through that mosaic, correct?
Yeah, it does.
I would object, Your Honor, to facts not in evidence.
Overruled.
And this is an overhead, correct?
It is.
And does it look like a fair and accurate representation of what the property is at the flagship building?
It is.
I'd ask to move it into evidence, Your Honor.
Any objection?
No objection.
So admitted as defense exhibit. Is this one 1?
This is 2, Your Honor.
Defense exhibit number 2.
So, just so the jury, may I have him step down so the jury can see, Your Honor?
Yes.
If you wouldn't mind. Thank you, sir. Just so we're clear, the red outline in Defense Exhibit 2 is the flagship building. Is that correct?
Flag building.
The flag building. And it is on, I think, 215, is it South Fort Harrison?
South.
And this is alternate 19, which is also Fort Harrison. Is that correct?
Yep.
And this road runs north and south, correct?
Correct.
And this is the area of the mosaic, correct?
Correct.
And a large portion of this mosaic is on public property, correct?
It is.
And in fact, the city of Clearwater had to enter, the Scientology had to enter into an agreement with the city of Clearwater in order for them to put that on public property, the portion of it, correct?
I'm not sure. I don't know.
Okay, but you do agree with me that about half of that mosaic is on public property?
I agree.
Okay. Thank you, sir.
You can be seated. Thank you.
When, was it 4 of you that were, 4 people, security came out?
3.
3 on the video? Who's the 4th person, or is there only 3?
Only 3 security guards.
Okay, so there's 3 security guards. 2 of those security guards have rubber plastic wheelbarrows, correct?
Correct.
And it's filled with hot water, correct?
That's not the case. It was cold.
Well, this wasn't the first time on that day that the 3 of you poured water out there to go onto the mosaic, onto the public property, and onto somebody like Mr. Aaron Smith-Levin, correct?
I did not throw water on him.
Did water hit him at some point in time?
Not mine. I don't know other people.
Mr. Gaffney's water hit him, correct?
Objection, speculation.
He was out there.
Overruled, but you need to set a foundation. You're just making assumptions.
I'll set it.
Proper foundation.
There were 3 times that you, Mr. Gaffney, and who was the 3rd person?
Nathan Mezenzev.
Mezenzev?
Mezenzev.
I will try to say it. And the first time, the water was hot, correct?
No.
It was never hot.
It was never hot.
So 2 barrels were brought out, wheelbarrows, the first time, correct?
Yes.
And then who's carrying the buckets? The third person, the first time that the 3 of you went out there.
I don't remember.
And did you go out there with the other individuals and just clean up the area that you claim was on your property?
I did stay on my property and I poured down the water from there.
Okay. Knowing that it was going to go into the city property area where the chalk was, correct?
That I was not sure about.
Where did you think the water was going to go?
Objection, speculation.
Overruled.
Where did you think all of that water was going to go when you poured it?
On the mosaic.
And in your mind, it was just going to stay on the portion of the mosaic that Scientology owns?
On that I'm not sure.
Well, did the water the first time the 3 of you went out there and poured it, did it go onto the public portion of the mosaic and the rest of the area that has the red brick?
I don't remember.
Let's go to the second time. Who is there on the second time water's thrown?
I'm not sure.
Were you there?
I was there.
Mr. Gaffney was there, correct?
I'm not sure if he was there.
You're not sure who else was with you?
No.
Well, let's talk about it. Once again, 2 large wheelbarrows filled with water and buckets were also carried out the second time, correct?
Yes.
And once again, they're poured down where the steps are, correct?
Yeah.
And that water once again traveled onto the mosaic, including the mosaic that is on city-owned property, correct?
Correct.
And it also went onto the red brick further down, correct?
That I'm not sure if it went all the way down there.
But you do agree it went on the public property, correct?
It did.
Now, prior to the third, well, let's talk about prior to the first water incident. There was a discussion that your group had, correct?
Can you rephrase it?
Objective relevance and hearsay, Your Honor.
What?
Hold on. Overruled at this point, but you need to clarify what it is you're talking about.
Who ordered the 3 of you to dump the water?
Objection, relevance.
Overruled.
Who ordered the 3 of you to dump the water? Are you not allowed to say?
No, I'm just trying to remember. I don't recall exactly.
Who ordered you 3 to dump the water the second time? Are you not allowed to say?
No, I'm just really trying to remember who said what.
And who ordered you to dump the water the third time? The 3 of you.
I don't recall exactly.
In fact, you don't recall any of the discussions prior to dumping the water the first time, correct?
What I remember is that we saw the chalk on the mosaic, so we decided to put some water down so it didn't get damaged. That's what I remember.
And do you remember the word cult being written out on the area in large letters?
Yes.
And they wanted you to make sure the water would reach the word cult in very large letters on the public property, correct?
Nobody ever said that.
So they wanted you to leave the word cult then. Is that what
Nobody
your
ever said that
testimony
either.
is?
I'm going to object to relevance, Your Honor.
Overruled.
Is that what your testimony is? They had no problem with the word cult written in large letters on that public property in front of your building.
I say that I didn't want the mosaic to get damaged.
And are you saying that mosaic was damaged that day?
No, that's not what I said. I said it might have, so I did something to prevent it.
Now, this wasn't the first time anybody's ever put chalk or powder on that mosaic, is it?
Objection. Impermissible character evidence, specific acts.
We can approach, please. Where are you going with this?
He's saying that, well, the theme so far has been that they wanted to protect the mosaic.
I figured that out.
They know that it's not been damaged because it's multiple times in the past. Cornstarch powder as well as chalk is put down. They've never had damage, so that's fair game for him.
So you're kind of making an assumption it's never been damaged.
Well, only he's got that answer.
It's not relevant as to what's going on at this time.
Well, it is relevant.
I'm going to overrule. I'm going to sustain the objection.
I like the overrule.
I understand. I understand. Have a seat, everyone. Thank you.
Did you have one of the wheelbarrows? Were you responsible for one of the wheelbarrows?
I had one, yes.
How many gallons of water does that wheelbarrow take?
Are you asking how many can fit or how many was in the wheelbarrow?
How many was in?
I would say a little over 25.
25 gallons?
A little bit over, yeah.
And so there's two wheelbarrows. So we have 150 gallons just in the wheelbarrows for the 3 times that it's poured, correct?
Yes.
And when these 150 plus the 5-gallon buckets each time are poured, you're not saying that Mr. Aaron Smith-Levin did not get wet on his feet, are you?
I did not look directly at his feet.
Did you watch the water and where it went?
Partially, yes.
And you don't want to say that it wet his shoes, do you?
It might have. It did. It did.
Well, did it or did it not?
Like under his shoes, not over his shoes.
Did you see the type of shoes he was wearing? Water shoes, water sneakers?
I don't recall which shoes.
Have you ever worn water shoes, water sneakers?
Objection, relevance.
Sustained.
May I have a moment, Your Honor?
Yes.
Nothing further. Thank you, Your Honor.
Any redirect?
Yes, Your Honor.
Mr. Lechner?
Mr. Madashi, were you keeping tabs on everyone around you as you tried to clear the property?
No.
No. And Your Honor, permission to publish defense too?
Yes.
Now, is this the black building?
It is.
Thing outlined in red?
Yeah.
How big is that building?
It's like a full block, essentially.
How tall is it?
7th floor.
So it's pretty big?
Pretty big.
Okay. And is this the area we're talking about?
Yes.
Okay. And are you responsible, is the Church of Scientology responsible, to the best of your knowledge, to maintain the entirety of this circular structure?
Yes.
Okay. And when you watched that video earlier, do you remember watching that?
Yeah.
When Mr. Gaffney walked down the stairs, was he still within the property line?
He was.
Okay. And who walked up to him in the property line?
Smith-Levin.
No, for Your Honor.
Yes.
You were also asked about difference between security and maintenance. As security, is it also your job to protect and maintain the grounds?
Yes.
Okay. No further questions.
All right, may this witness be excused?
We'd like them to remain on standby, Your Honor.
All right, if you will step down, you can stay in the building. Do not discuss your testimony with anyone that don't leave the building, okay?
Yes, Your Honor.
All right, thank you. Ladies and gentlemen, do you need a break? No? All right, state, call your next witness.
Yes, Your Honor. At this time, the people of the state of Florida call Nathan Mezensteff to the stand.
Stand next to me. Turn face forward, raise your right hand to the oath, answer loud and clear I do.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do. Step over here, please. Have a seat. Just one mic and speak in loud and clear voice.
Ms. Mead, you may proceed.
Thank you, Your Honor. Good afternoon, sir. Can you please turn and introduce yourself to the members of the jury?
My name is Nathan Mezentsef. That's spelled Nathan, last name Mezentsef.
And Mr. Mezensteff, I always start this way with any witness that I speak with. I just want to remind you at any time you're providing a response, I encourage you to look towards the jury, as it's most important that they hear and see how you're portraying the situation. I know it's awkward because I'm asking the questions. But Mr. Mezensteff, what do you do for a living?
I work in security for the Church of Scientology.
And how long have you done that?
7 years.
And now, where specifically do you work?
I work in all buildings in the downtown Clearwater area that the church owns, and on that day specifically was at what we call the Fly Building, which is 215 South Fort Harrison Avenue, Clearwater, Florida.
Okay, and just to clarify, when you say that day, is that July 29th, 2025?
That's correct.
Okay. And is that downtown Clearwater location, the one that you just mentioned, specifically located in Pinellas County?
That's correct.
Now, Mr. Mezensteff, were you present during an incident in which protesters were drawing on the sidewalk outside of that Flag building?
Yes, I was.
And why were you there specifically?
Because I work for security for that property, and I was doing my job.
And where were you in relation to the protesters?
Mainly I was inside the building. Occasionally I was outside the front entrance of the building within our property line.
Okay. And at any point, did you witness one party throw a blue powder at one of the protesters?
Yes, I did.
Or I'm sorry, did you witness one of the protesters throw blue powder at one of the members that you were working with?
Yes, I did.
Okay. And is that individual that you witnessed throw that blue powder in this courtroom here today?
Yes, he is.
Can you please point him out and identify him by an article of clothing he's wearing?
He's seated in between the two gentlemen here with a gray suit and a goldish colored tie.
Your Honor, let the record reflect that the witness has identified the defendant.
Record so reflect.
Now, Mr. Mezensteff, can you tell this jury here what you witnessed that day?
Yes. So we were putting water down onto the mosaic in order to protect the mosaic, because we were concerned that what was occurring would create damage to the mosaic, which we were responsible for maintaining. And at the time, one of my colleagues, Mr. Gaffney, was putting down some water to the right of the building when you're facing towards the street. And Mr. Smith-Levin approached my colleague, Mr. Gaffney, and threw this blue powder directly at him, at which point Mr. Gaffney retreated backwards. and then we went back inside.
Okay. And if you saw a video of the events that you just described to the members of the jury, would you recognize that?
Yes, I would.
Your Honor, permission to publish states 1.
Yes.
Jamie,
I got you, by the way.
let's get ready to party, baby.
Now, can you indicate, you can stand up if it helps, which individual you are in this captured image right now?
The one furthest left when you're looking at the screen.
Okay.
Come on, bring it. Bring it. Bring it. Oh, it's just going to hit our water barrier, you losers. Yeah. Here you go.
I got everybody in it, but.
And are you working as a team there?
Yes, we are.
Who are you working with?
I'm working with Tyler Gaffney, Mateo Medaski, and Dmitry Zenchenko.
Do you all have a shared purpose?
Yes, we did.
And what is that purpose?
To protect the property and the people within the property.
And just to be clear, do you have one of those big gallon buckets?
Yes, I did.
And what is the intention of what you're doing there?
To put water onto the mosaic, which you can see is full of what I assume is whatever that blue material powder is, which we were concerned would damage that mosaic.
Okay. And at any point, did you witness any of the other individuals who are alongside of you dumping water at protesters?
No, I did not.
Instead, did you witness them just dumping the water towards the ground?
That's correct.
Does
Just
that
to the
go
ground.
for Mr. John Gaffney as well?
Yes.
Did you witness Mr. Gaffney walk towards the defendant at any point?
No, I did not.
Did you witness the defendant walk towards Mr. Gaffney at any point?
Yes, I did.
Okay. Were you able to observe that blue powder make contact with Mr. Gaffney?
Yes, I was.
Were you able to observe the aftermath of that contact with Mr. Gaffney?
Yes, I was.
Can you tell the members of the jury what you saw?
He was covered in this blue powder, and we went back inside the building, and I assessed what had occurred, and it was all over his gear and his uniform, as well as on his face. So we were not sure, if that was going to, I wasn't sure how he was feeling and what was happening, but he definitely had it all over his uniform and his clothing. Yeah.
Your Honor, permission to publish defenses 2?
Yes.
I just want to make use of this diagram that was presented by defense using that capture that we have up there right now. I'm actually, Your Honor, can I have a witness step down?
Yes.
I'm just going to have you come right over here for me. So I just want to be clear for the members of the jury and what they're seeing. If you look at this here, are you able to see where the flag building is located?
Yes, I am.
Can you indicate that for the members of the jury?
It's this.
Okay. And then looking at that photo that's captured, and sorry, for the record, he just indicated the red outlined portion. Looking at the photo, the capture that's up there right now, are you able to see that location on this diagram? Can you indicate that?
These are the stairs here at the end of you can see the orange or darker colored bricks, and then it turns white. So that's where the bricks are, and then where the white begins is where the stairs begin.
And for the record, he's indicating if looking at the image, it's the top left-hand corner of the red box, the little rounded area. And you indicated that the steps were on here. At any point, did you leave the steps? You personally, did you leave the steps?
This instance?
Correct. And at any point, speaking to the video, when Mr. Gaffney comes down, can you indicate on this diagram here where he's located?
Right here at the bottom of the steps next to that, where you can see the plant is right where the handrail is. He steps down there, and you can see the bottom of we can't really see the steps, but it's right in that location.
Okay, and is that still inside that red box there?
Yes.
Okay. You can see. And I noticed that on during your testimony, you directly mentioned that you remained on your property. Was that intentional?
Yes.
Okay. Did Mr. Gaffney also remain on the property?
Yes.
Okay, a moment to confer.
Yes.
Nothing further, Your Honor.
Any cross-examination from the defense?
Yes, Your Honor.
All right, Mr. Theophilopoulos?
Good afternoon, Mr. Messenstedt?
That's correct.
Did I say that right? Good, thank you. Now, you're with security, correct?
Yes, sir.
And how many years have you been with security?
7 years, sir.
And there's also a maintenance personnel that also has a flag crew, correct?
That's correct.
And the maintenance personnel and flag crew is responsible for the grounds of the property, correct?
Yes, sir.
And in fact, they're responsible for cleaning up the grounds as well, correct?
That's right.
And on this date, security was called in for a specific purpose, correct?
I'm not sure what do you mean by called in?
Well, let me ask you this. Who ordered the three of you, or the four, to go to the area with the buckets of water and the wheelbarrows?
I mean, we had that by group agreement.
So nobody ordered the group to do that?
I mean, we observed what was happening and made the decision to do that.
And how long had you been observing what was going on out there? For a while, correct?
Yes.
And it's bothersome. Let me show you Defense Exhibit 3 that we introduced a little earlier. You see that?
Yes.
And do you see the word cult to the left?
The white writing?
Yes.
Yes, I do.
And the group, the security group, how many of you were there?
3.
And the security group, you saw them chalking the grounds, the public grounds, with the word cult, correct?
Well, you said you. I don't know who you're referring to with you.
The group, the security group.
I saw who chalking.
Somebody.
I did see somebody chalking, yes.
Okay, so it wasn't a situation where the three of you just, the doors opened up and you came out without seeing anybody doing anything out there and just poured that water, correct?
That's correct.
So how long had you observed the chalk on the public property?
Maybe 30 minutes or so.
And so after 30 minutes, who gave the order to fill up the buckets and the wheelbarrows with water?
Perhaps one of my superiors. I mean, we just hadn't intended to do that on that day when we saw that happening.
Well, you're not allowed to do it on your own. You have to take orders, correct?
In some cases, yes.
Do you know in this case whether you took an order or whether the three of you just decided to do it?
I don't remember.
And how many times is it that you recall water was filled up in the wheelbarrows and in the 5-gallon buckets?
2 or 3 times.
Okay. And it became problematic at some point in time because the water wasn't reaching the word cult, correct?
I don't know.
Well, your security group wanted the word cult removed. They wanted water on it, correct?
What I stated earlier was it was to protect the mosaic.
That wasn't my question. My question was the word cult. Your security group wanted that removed, didn't it?
I don't know.
Well, were you comfortable with the word cult being written on the grounds there, on the public grounds? Were you comfortable with the word cult being written on the public grounds there?
Not entirely.
You wanted it removed, your security group, correct?
I don't specifically remember that. The main intention was to protect the mosaic from damage. We were also responsible for maintaining that sidewalk.
Do you know if chalk had ever been placed on the mosaic in the past?
Yes.
Was it ever damaged?
It required extensive cleaning, so yes.
Was it ever damaged?
Yes.
You had to bring in a professional company to clean it, is what you're saying?
Not professional, but our own maintenance personnel had to do extensive work to ensure that it was properly kept up and cleaned and maintained.
And you would agree with me that that mosaic, well, the property line, Scientology doesn't own that whole mosaic, do they?
Well, per the property line, no.
Because a large portion of that mosaic is on public property, the city of Clearwater, correct?
Yes, however, we are responsible for maintaining that property despite it being public property.
So the public can go on there, and if they decide their First Amendment right, and they want to put stuff down on it, they do, correct?
Yes.
And are you saying that Mr. Aaron Smith-Levin was on Scientology property at the time the blue powder and the water came out?
Yes, I am saying that.
May I have him step down with Defense Exhibit 2, Your Honor?
Yes.
Do you mind stepping down, sir? Now, you testified earlier on direct examination that it happened somewhere down here, correct?
Yes.
This is alternate 19, Fort Harrison, correct?
Yes.
And Fort Harrison runs north and south, correct?
Yes.
And if you look at that mosaic, there is a ramp with a garden area that goes around here, correct?
That's correct.
And then on the other side, which is north, there is another ramp with a little garden, correct? Is that a yes?
Yes.
The powder and the water incident occurred on the public property, correct?
No.
So you're saying that where that, what's it say, no trespassing or something? Private property, it says, where that sign is it your testimony that the water bucket didn't go down there on Mr. Levin and then he released the powder?
I don't understand the question.
My question is, you're saying everything happened on the property of Scientology, correct?
That's what I see, yes.
Well, can you tell us on this exhibit up here, where is the sign that says private property?
It's too pixelated, I cannot tell.
I understand. Well, let me ask you this. Do you see where the sign is on there, sir?
Yes, I do.
And do you see the greenery to the left of it?
Yes, I do.
Can you show us on this diagram where that greenery is?
It's somewhere in this location. It goes around here, and then it's covered by a tree or something.
So it didn't actually happen on the other side, the southern side. It happened on the northern side, correct?
Of what?
Of the mosaic, the property.
Yes. It happened over here. That's what I said.
Are you saying it happened on the south side or the north side?
The north side.
Then
The north side.
I understand, but why are you pointing to the south side is what I'm confused about.
To the south side. I'm pointing here. This is the stairs, and that's the northern part of the stairs. That would be the southern part of the stairs. That would be the northern part of the stairs.
And you agree with me that the mosaic, pretty much it goes right down the center, the property line, correct?
More or less, yes.
Thank you. The first wave of water that the security personnel brought out, it was hot water, correct?
No.
Never used hot water.
Never used hot water.
Let me ask you, there's also water blasting guns on the building, correct?
Can you please define water blasting gun?
Well, what kind of device is there on the front of that building right there in Defense Exhibit 3 that expels water from the building? Tell us about that.
I cannot see such a device.
Have you ever seen it?
I'm not sure what you're referring to.
Is there a water gun type mechanism on the building?
Do you mean a faucet?
No, a water gun that will blast water out from the building For instance, if people were out there protesting.
No.
Never seen that.
I've seen a faucet. Or a spigot.
Nothing further, thank you.
Any redirect?
Yes, Your Honor. Mr. Messenstaff, I'm just going to go through a few things that were just addressed on cross-examination, okay?
And for the record, Ms. Mee.
Thank you, Your Honor. I just want to start out by talking about this differentiation that's attempting to be made between maintenance and security. I just want to clarify, were you acting in your role as a security officer on July 29th?
Yes.
Did that role include protecting the mosaic?
Yes.
Were you also working alongside maintenance?
That's correct.
Were you simply acting as assistants?
Yes. Security involves protecting the property as well as the people of the property.
Now I want to shift your attention to what's up here on the screen. This word cold. Been emphasized. Did that have any influence on what you were doing on July 29th?
Not particularly. I mean, like I said, the intention or our job is to protect the property and the people of the property.
And you also mentioned that it was to protect the mosaic, is that right?
Yes.
Just for, make it very, very, very clear. Can you stand up and indicate what mosaic we're talking about here?
The mosaic stretches all the way to the edge of the brick wall. The design is in the center, but the mosaic stretches all to there. So I'm talking about that. Even if it is partially public property, we're still responsible to maintain it and make sure that it looks nice and it's presentable.
Okay. Commissioner, public defense too?
Yes.
I just want to, again, use this in corroboration with that image there. You're indicating, just to be abundantly clear, on your direct examination, you indicated, and I'm going to have you step down again if that's okay, I had you indicate what we were seeing in the screen grab on here. Can you do that again? So what are we looking at in that screen grab on this display?
This video is irrelevant to the time of Mr. Gaffney's.
Yes, I understand. But speaking to what I'm asking you, that image there, where is that on here?
The image?
That whole view, where would that be?
Well, that is an overview of the entire mosaic area.
Okay. And is part of that falling in that red property line?
Yes.
Okay. You can see. And the battery that we witnessed on the video.
Objection, Your Honor. It probably will be.
You rephrase the word battery. That's for the jury to decide.
Yes, Your Honor. And in the incident that we witnessed on the video, where the water and the powder were thrown. Again, can you indicate on this screen grab for the members of the jury where that happened?
Too short. It's right up there next to that handrail. Mr. Gaffney took a few steps down those stairs. Right at the bottom of those stairs is where the incident occurred.
And would that be the left-hand side of the steps looking at this photo?
That's correct.
Okay. And to your knowledge, is that on the property of the Church of Scientology?
Yes.
A moment to confer.
Yes.
Just one final question, Mr. Messenstaff. Regardless of property line, where things took place, any of that, does that change what you witnessed on July 29th?
No. It doesn't change what I witnessed. Whether it occurs on a public property or a private property, it's still the same thing occurred. It's, to me, irrelevant.
Nothing further, Your Honor.
All right, may this witness be excused?
We ask you to remain on standby, Your Honor.
All right, I'm going to ask you to step down. Do not leave the courthouse. Do not discuss your testimony with anyone, please.
Yes, Your Honor.
All right, thank you. State, do you have any further witnesses?
Yes, Your Honor. At this time, the state of Florida calls Officer Frost to the stand.
Frost?
Yes.
Is it you need time for a restroom break? Okay, don't call him yet?
Yes, Your Honor.
All right, ladies and gentlemen, we're going to go ahead and take a, let's say 15-minute restroom break, so that'll be about 5 minutes to 4. Close your notepads, leave them upside down on the chair here. Do not bring them back with you. Do not discuss your testimony with one another. And that's about it, okay? And close your pad up there. It needs to be closed.
Go ahead and leave your pads and pens on the seat.
Mr. Jordan, did you close your pad up? I appreciate it. Thank you.
Your Honor, the jury's out of hearing of court.
All right, it's also a good time for us to address the reserve motion limited that I have at the parties with the attorneys will approach the bench.
Yes, Your Honor.
Okay, so tell me, the defense, what you expect that this witness is going to testify to?
I mean, it's all after the fact. I anticipate he'll come and say he came. He was called. He did an investigation. He made a determination not to make any arrests at that point, and that was the end of his involvement.
All right, but there's a motion limited here to exclude him testifying that he was going to arrest both of them?
Write it up as a double battery.
Okay.
Not arrest anybody. He was just writing up as a mutual battery, mutual combat scenario.
Okay, and you all want that excluded for what reason?
For the state is of the perspective that what the officer has probable cause for does not matter for what we are actually ultimately charging. In this case, we charged a battery against Mr. Aaron Smith-Levin. That the fact that there was a potential conversation that was had in the moment about a double battery is completely irrelevant to the fact that we are here today for a charge of battery that the state has brought, and it's the state's right to bring a charge. And that I particularly want to emphasize the difference between the standards that are being applied in front of me.
All right, did he bring both of them to you to make a decision on?
No.
He didn't bring any.
So it didn't even.
Well, he brought a non-arrest.
No. No, he didn't do that at all.
How did this case come about?
They called. He brought an arrest. This was an arrest.
No, I thought you were talking about the other.
Well, the case gets to you somehow. Either they get arrested or there's a non-arrest.
This was an arrest? I thought the other, no, this was not an arrest.
Okay, let me check.
This was a direct file from you guys.
You pulled his bond, then he got arrested.
Well, he was out because there was no bond.
Correct.
No, he was arrested on July 31st. As an arrest complaint, he posted a cash bond.
Oh, I thought the other one was the arrest. The other was the
That's what I thought.
This is case, no, let me check this. This is one separate trial, right?
It is.
25-10869.
No, I apologize. I didn't
No,
make
he
the
was
arrest.
arrested.
This was the arrest. Okay.
Okay, so when was the arrest made? Looks like on July 31st. For July 29.
Then I think it's relevant. I think it's more relevant now than if they hadn't done it. Because now, at the time it was a mutual combat standard. No
What did the officer say to them?
So he, in his original arrival, he was having a conversation with the defendant. At that time, he said, well, I'm probably, something along the lines of, I'm probably going to write this up as a mutual battery. We have to see what the state does with it. Kind of basically speculating for what the state is going to do. At that time, he, and I'm having a conversation with him in preparation for trial, he had made an assumption based off of a snippet of a video he had seen. So I think by bringing in that statement.
Okay, well then, I'm going to let it in. Your cases are not applicable that you gave to me. I've read them. I'm going to let it in. You can actually have him testify as to why it is that he said that and why he changed his mind. But I guess really my first question is why is this witness testifying? It's not going to be one of these, I looked at the video and made a decision to arrest, right, because that's we're backing in hearsay and everything else.
Mr. Smith-Levin makes specific statements to him.
Okay.
That goes to intent.
All right. then as long as there's for a reason other than you backdooring stuff, then that shouldn't be coming in. Okay.
If that's coming in, our position is it's opening the door to the statements that Officer Frost made.
That's what we were just talking about.
Okay, okay, I just want to be sure.
You won that argument.
Thank you.
All right, we're breaking till 5 minutes to 4. All right, hold on before we send anybody out there. Ladies and gentlemen, when you walk out that door, I expect your behavior that you've had in here so far, which has been pretty good, actually very good, is to be the same outside there. I don't want anybody taking out any phones, any videos, anything like that. And I believe that the issues that we were having before we came in here were people that were not part of your group. It was somebody else, which is known to the courts. But I want the same civility out there as I saw in here. When you come back in, the deputies again will sound the halls to come back in, and I will seat you the same way that we did before. And that's going to be a little bit before 5 minutes to 4, because I want to get the jury back in here at 5 minutes to 4. Okay? All right. Thank you. All right, I just need to let y'all know.
Let me give Mr.
Let's get your client in.
Okay. You want anybody else in yet?
No, not yet.
Just Mr. Smith-Levin. Go out there.
All right, Sergeant Van Buren told me during the break here that I think that the deputy's office here got a call from an anonymous caller saying that some YouTuber that goes by the name of Dodge Landsman, we believe he was the guy that was sitting in the far back corner over there, had contact with a juror at lunchtime at Cracker Barrel by the name of Sheriff Fullerton. Well, we know Sheriff Fullerton is your witness, not a juror. So I think it's nonsense, but I wanted to bring it to y'all's attention. I made it clear to the jurors if anybody had any contact with them, they need to let us know. But I think it's more somebody having contact with your witness.
That's correct, Your Honor. Sorry, did you say it was one of the people in the back row?
I think they said his name. He goes by Dodge Landsman. Is a redheaded guy. They showed me a picture of him.
He's known to me, Your Honor.
Okay. So I don't know what kind of contact he had with her. What apparently he does stuff that you do. So I don't know if there's any concerns anybody has.
No, Your Honor.
All right, just somebody trying to cause some trouble. All right, let's bring the crew in. Whoever wants to come in, sound the halls. That come in now.
Yes, Your Honor.
If you're proposing complaint, come on in, make sure cell phones are turned off, get your quiet, please. All cell phones are tapped, turn back and let them off.
That's why you had thought that, I think.
No.
He's not. We have no.
Okay. There's no way to hold him.
No, he was. I released him.
Okay.
Are you guys really fighting about who's going to sit in the back seat over there? All right, I'm going to remind everyone in regards to the rules that I had before that you are to keep a straight face in the courtroom. You are not to have any facial expressions during any of the testimony here, any response to any of the testimony here. All phones are to be away. They are to be turned off. They are to be in a pocket, a purse, or someplace that is not visible. If we see it, I assume you are videotaping or audio taping, and your phone will be confiscated from you, and you may be held in contempt of court, facing up to 6 months in the Pinellas County Jail. Everybody clear? All right. Thank you. Bring the jurors in.
Yes, right.
Jurors present, seated, go ahead and have a seat in the jury box.
All right. Everybody get a sufficient amount of time for a break?
Too long.
Too long. I would have pulled you back in earlier. All right. State, call your next witness.
Yes, Your Honor. The state of Florida calls Officer Frost of the Clearwater Police Department to the stand.
Officer Frost?
Ms. Nee, you'll be doing the direct?
Yes, Your Honor.
Stand right next to me, please. Turn and face the front. Raise your right hand. Receive the oath. Answer loud and clear. I do.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do. Step over here, please. Have a seat. Adjust the mic. Speak in a loud and clear voice.
All right, Ms. Nee, you may proceed.
Thank you, Your Honor. Good afternoon. Can you please turn and introduce yourself to the members of the jury, spelling both your first and last name for the record?
Yes. Good afternoon. My name is Officer Brian Frost, B-R-I-A-N. Last name is Frost, F-R-O-S-T.
Now, Officer Frost, where do you work?
I currently work at the Clearwater Police Department.
And how long have you worked there?
A little over 3 years now.
Did you work with any other agencies prior to working with Clearwater?
Yes. In total, I have a little over 10 years of law enforcement experience, spread between Florida and North Carolina.
Okay. And now, can you tell the members of the jury what training and experience you have to undergo to become an officer with the Clearwater Police Department specifically?
Yes. We have to attend a standardized police academy that every law enforcement officer in the state of Florida has to go through. It's approximately 5.5 months, give or take. You're taught in various high liability topics like shooting, driving, first aid, investigating complex situations involving domestic cases. There's role-playing scenarios. There's hundreds of hours devoted into investigations. Once you're released from a police academy, the training's not done. You go through a field training process with the department that you're at, in which you're closely watched and supervised by a field training officer, and that takes about 4 months, and throughout that process there's an additional few weeks of training that the department gives to make sure high liability topics are covered.
Did you complete all of that training?
I did.
Okay. Now I want to turn your attention to what brings us here today, specifically July 29, 2025. Were you working that day?
I was.
In what role were you working?
I'm assigned to the downtown community policing team. Essentially, I just respond to calls for service in the downtown Clearwater area.
Okay. And did you respond to a call for service at 215 South Fort Harrison Avenue in Clearwater?
I did.
Is that located in Pinellas County?
It is.
When you arrived on scene, can you tell the members of the jury what you observed?
Yes. When I got out of my marked police vehicle while walking towards 215 South Fort Harrison, on the ground there were several words written in chalk, one of which I could see that stated the word Colt, and it looked like there was splash water around. I could see several cameras set up on tripods, so it looked like the incident was being filmed in one way or another.
Did you conduct an investigation that day?
I did.
And after your investigation, did you ultimately transport the defendant in this case?
I did.
And where did you take him to?
I transported him to our police department at 645 Pierce Street.
At that point, who did you turn the investigation over to?
Detective Bieber with the Clearwater Police Department.
And while you were on the scene of 215 South Fort Harrison, were you working with any other officers?
Yes, I was. Officer Reich.
Okay. Is the man who you transported in this courtroom here today,
He is.
can you please point him out and identify him by an article of clothing he's wearing?
Yes, he's off to my right. He's wearing a blue suit top, white undershirt with beigeish colored tie.
Your Honor, let the record reflect that the witness has identified the defendant.
Record so reflect.
Now, before we go, I just want to discuss two main statements that the defendant made to you. Did you speak with the defendant?
I did.
Okay. Did he tell you anything about blue powder hitting the victim in this case?
He did. Made a comment referring that they were stating that a battery occurred because chalk was thrown in the air and carried by the wind.
Okay. And then, did you ask him about his appearance in any way?
I did. He looked very wet to me, and I specifically asked him why he was wet, to which he stated that he was sweaty, heavily sweating.
Okay. At any point, did he indicate water was thrown on him?
Before that statement or after? Or at any point? At some point, he made a statement that water was thrown at or on him.
Okay.
Yes.
And did he state that that was the reason for his appearance?
No. He specifically stated it was from sweat.
A moment to confer.
Yes.
Nothing further at this time, Your Honor.
Will there be a cross-examination?
Yes, Your Honor.
All right, Mr. Perlman?
Afternoon, officer.
Hi, good afternoon.
Just a few quick questions for you. So you respond on scene to the investigation, right?
Yes.
Okay. And when you go to the investigation, obviously you've been to this property in this location before, right?
Correct, many times.
Okay. Now I'm going to show you what's been entered in as Defense Exhibit 3. Okay. Are you able to see that, officer?
Yes.
Okay. Now I just want to clear. Your Honor, may I approach just to clarify when it comes back up? May I approach the exhibit?
Yes.
Now, sir, there's no other signage regarding the trespass aspect except for the signage right by kind of the rail going down and the greenage, the top center of that. Do you see what I'm talking about?
I see the sign, I just don't know what it says, but yes.
Correct. Well, is it understood that that is kind of the cutoff in these protest situations? That's where people can protest up to but not go up the stairs?
Yes, from my understanding.
Right. And that's your understanding from going out there, that's kind of just the common accepted, this, you can protest here, but you can't go past that sign and up the stairs, correct?
Yes.
Okay. And that's what everybody has abided by, essentially, in this situation anyway?
Yes.
Okay. So that's the common practice. You arrive on scene, you have a conversation with my client before you transport him, right?
Yes.
Right. And at the scene, it is relayed to you that the other party, in this case, threw water on him, correct?
Yes.
All right. In that situation, he tells you they threw water on him. He had indicated, I appreciate the torso and the shirt, he was sweating, but the other components, he had indicated he had gotten water thrown on him earlier, correct?
Yes.
Okay. Not just the last time that we talked about, but throughout the course of these 3 different interactions.
Yes, I remember him making a comment that previous interactions he had water thrown on him.
Right. And so what we saw on that video, I mean, you see the video that we're talking about where, you know, the individual comes down, water is thrown, the powder is thrown?
Yes.
Okay, so you've seen that video in particular?
From which point of view?
Either.
I've seen the point of view from the live stream from your client.
Got it.
I think I vaguely remember the other point of view. It's the same video, just from a different reference point.
Yeah, from like behind the Scientology building, or like
Correct.
From where they were at?
So the one that I specifically remember is from your client's live stream, which is this frame, essentially.
Got it. And did you see that at the time, or did you see that later?
At the video?
Yeah.
At the time.
Okay, so you saw that at the time, and you did not charge my client at that point, that day, correct?
With battery? He was charged that day with battery.
It was that day?
Chalk day, yes.
Okay. Just to be clear, you didn't indicate that this was a mutual combat scenario or a mutual battery scenario?
No, I absolutely did.
You did? Okay. So you said this is a mutual battery, and that's how you're going to write it up?
Yes, that was the initial opinion.
Okay. And that was after you saw the video?
Yes.
And you agree someone throwing water on another individual, that is a problem?
Yes. I've said it multiple times on video, too. So.
I know. Sure. That's just going through it, right? You said it matched, in your opinion, on both counts, the water being thrown on him and the chalk being thrown, those were battery scenarios, correct?
Yes, I gave very specific pointed examples. If somebody threw water on me, that would be a battery, and vice versa. If somebody threw water on somebody else, it would be a crime.
When you take him down to the station at that point, he talks to you, he goes through everything with you, correct? I mean,
Yes.
even at the scene, he talks to you, he explains everything that happened?
Yes.
And does he provide you the live stream?
That was the first interaction, within the first minute, he referred me to his live stream.
Right, he shows, here's what happened, here's how it played out.
Yes.
Okay. Your Honor, just one moment.
Yes.
Now, sorry, I just want to ask you, you said, you've already said this, but I want to clarify in more detail. You said you were basically making a determination this was a mutual battery situation and you weren't going to make an arrest initially, correct?
Initially, correct.
About 15 minutes go by and then you decide you're going to arrest Mr. Smith-Levin, correct?
Yes.
Was that after you talked to one of the representatives of Scientology or what? I mean, in those 15 minutes, there was a change. Is that correct?
I didn't talk with it was with a Clearwater Police Department supervisor that I conferred with.
Okay, so initially you were not going to make an arrest. After conferring with the supervisor, you decided at that point, or at least the supervisor decided to make the arrest.
Yes, it was reframed with contact, but yes.
Just one moment. I have another question.
All right, redirect.
Yes, Your Honor. Officer Frost, I just want to dive into that mutual combat just a little bit, or that mutual battery, double battery concept a little bit further. So what made you initially think that this was a mutual battery or a double battery?
So when I first got there, I was immediately referred to his live stream where I watched the video, and while watching he was trying to explain himself, so I had divided attention. So while I was watching the video, I looked down at the part where the battery took place, and I made an initial opinion without taking the entire video into context. So then later on, with conferring with the supervisor, they kind of redirected my focus with the totality of the circumstances and not just that very specific moment.
Okay, so just to clarify, when you had that contact with your supervisor and you were making that ultimate decision, did you then view the video in a more comprehensive nature?
Yes, I did.
So that initial viewing, would you say, was a little bit confined?
Yes.
Okay. And did you ultimately rely on your final viewing to make your decision?
I did.
Did you ultimately charge 2 batteries?
No, I did not. I only charged 1 battery with the defendant in this case.
Okay. And just to be clear, there was a point made, and I just want to reemphasize one more time. Did you have any contact with the victim in this case?
I did not know, not personally.
Okay, so did the victim tell you anything that swayed your opinion?
No, I had no contact with the victim.
Did you have consistent contact with the defendant?
Yes.
Okay. A moment to confer.
Yes.
Nothing further, Your Honor.
May this witness be excused?
We ask that he remain on standby.
All right, officer, I'm going to advise you that you need to stay here in the courthouse. You are not to discuss your testimony with anyone, please.
Yes, Your Honor.
Thank you. Call your next witness.
Yes, Your Honor. The state of Florida calls Officer Reich of the Clearwater Police Department to the stand.
Stand next to me, please. Turn to face the clerk, raise your right hand, repeat the oath, answer loud for your ID.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do. So up here, please, have a seat for just a moment. You're allowed for the voice.
All right, Ms. Mee.
Thank you, Your Honor. Good afternoon. Can you please turn and introduce yourself to the members of the jury, spelling both your first and last name for the record?
Yes, ma'am. I'm Officer Owen Reich with the Clearwater Police Department. First name Owen, last name Reich.
And Officer Reich, you just indicated you're with the Clearwater Police Department. How long have you been with the Clearwater Police Department?
It will be 4 years in July.
Did you have any prior experience with any other agencies prior to Clearwater?
No, ma'am.
Can you just tell the members of the jury what training and experience you have to undergo in order to become an officer with Clearwater Police Department?
Yes, we have to attend a 22-week law enforcement academy. Once we pass that, we have to attend in-service, like a post-academy training. After that, it's a 4-phase FTO program, which usually is 4-ish months. After that, you get released as long as you pass all the tests and demonstrate to the FTOs that you can do the job.
And just for clarity purposes, you just use the acronym FTO. Can you tell the members of the jury what that stands for?
Yes, FTO is a field training officer.
Okay. And did you undergo all of that training?
Yes, ma'am.
Okay. Now I want to turn your attention to what brings us here today, specifically July 29th, 2025. Were you working that day?
I was.
In what role were you working?
As a patrol officer assigned to the downtown community policing team.
Okay. And did you respond to a call for service at 215 South Fort Harrison Avenue in Clearwater?
I did.
Is that located in Pinellas County?
Yes, ma'am.
Okay. Can you tell this jury what you observed when you arrived to the scene?
So I arrived, there's a bunch of what appeared to be art on the sidewalk, also a lot of water. My job was to find the victim in the crime.
Okay.
I found the victim, talked to him, got his side of the story, took photographs, and also a video of the surveillance video of the altercation that took place, and then provided all that to Officer Frost.
Okay, so were you working with Officer Frost in this investigation?
Yes, ma'am, we were doing like a joint investigation.
Okay, and then you also indicated you took photographs. Would you recognize those photos if I show those to you?
I would.
Your Honor, permission to approach the clerk?
Yes.
I'm retrieving what has been marked as States Composite 3A through C.
Yes, sir.
I was just showing defense. Permission to approach the witness?
Yes.
Officer Wright, I'm just going to have you flip through those.
Yes, ma'am.
Do you recognize those?
I do. These are the photos I took on the scene.
Okay, and do they fairly and accurately depict what you observed on July 29th?
They do.
Your Honor, at this time, the officer in evidence what has been pre-marked as States Exhibit 3, Composite A through C.
Any objections?
Mayor.
All right, so admitted. And what number is this? It states exhibit
3,
A through C?
Yes.
So admitted.
And I'm just going to put these up here. Can you just tell the members of the jury what they're seeing in these photographs? Just describing what they're seeing?
Yes, so this is the victim in the case. All the blue powder is what was the victim stated that was thrown at him and on him. This is a better picture of the powder on his shirt and pants.
Is there powder on his face as well?
Yes, up on his like forehead by his eye.
And that was States 3B. The first references were to 3A. Now moving on to 3C.
And then this is the victim's back. You can also see the blue powder on his radio and his shirt, and then down his pants, and even on his shoes.
And did you take these photographs immediately after coming into contact with the victim and conducting your investigation?
Yes, ma'am.
A moment to confer, Your Honor?
Yes.
Nothing further, Your Honor.
Any cross-examination?
Just briefly. Afternoon, sir.
Mr. Perlman?
Afternoon.
Yes. Back to States 3. Just showing you what is States 3A. Do you see the buckets down here in the background?
Yes, I do.
Okay. Were these the buckets that were involved with them throwing water onto the mosaic and the people down there?
I'm not 100% sure. I'm not aware of that part of the investigation. My investigation was speaking to the victim.
Okay. There's 1, 2, 3, 4, 5, 6, 7. There's like 8 of them there. Do we know what they were for in the picture you took?
I do not personally know.
This isn't your first time out at this location, correct?
Yes.
This is your first time out?
My first time, yes.
Okay. A location that, in this situation, it's your first time out there. You respond. You're simply trying to figure out what happened to the best of your ability, right?
100%.
Okay. You didn't observe anything? As far as like videos or anything of that nature?
Videos, as in the security camera footage? Yes.
Okay, so you did observe those?
Yes.
So those were given to law enforcement, including Officer Frost, right away, correct?
Yes.
So everyone had that before any decisions were made, right?
I believe so, yes.
Right. Were you involved with the supervisor's conversation with Officer Frost?
I was not.
Okay. So other than talking, taking photographs, that was kind of it for you, right?
That's all my involvement, yes, sir.
Good for you. I have nothing further, sir.
Any redirect?
No, Your Honor.
May this witness be excused. Hold on, I gotta find out.
Remain on standby, Your Honor.
All right, officer, I'm going to advise you that you cannot leave the courthouse. Do not discuss your testimony with anyone, please.
Yes, sir.
Thank you. State, call your next witness.
Yes, Your Honor. The people of the state of Florida called Detective Daniel Bieber.
Aaron, next to me, please. Turn face to the clerk, receive the oath, answer loud after I do.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth.
I do. So over here, please, have a seat. Just the mic. Speak with loud, clear voice. Sir,
All right, Mr. Lechner.
That's right. Afternoon, Detective. Could you introduce yourself to us?
Absolutely. My name is Detective Daniel Bieber with the Clearwater Police Department.
And then can you spell your name?
Daniel Bieber.
And is it Bieber like the singer?
It is.
Okay. Now, where do you work?
Clearwater Police.
And how long have you been there?
About 4.5 years now.
Where were you before that?
I worked for Pinellas Park Police for 2 years, and then prior to that I was out of state in Maryland for about 5.
All right, and I might have missed it. How long have you been a detective?
2 years.
Okay, and what kind of training does it take to become a detective with the Clearwater Police Department?
I mean, in addition to the basic academy level stuff, you go through interview and interrogations, which is a 40-hour course through SPC, additional courses through FBI and other entities like that, and then in addition to that, you go through all kinds of basic interview, evidence collection, stuff like that.
Okay, now I want to direct your attention to kind of what brings us here today. Were you working on July 29th, 2025?
Yes, I was.
What were you doing that day?
I was called in to assist with an investigation that patrol was working.
And what investigation was that?
It was in reference to an alleged battery.
And who had been alleged to commit that battery?
An individual by the name of Aaron Smith-Levin.
Did you have an opportunity to interview him?
I did.
And you recognize Mr. Aaron Smith-Levin here in the courtroom?
Yes, sir.
And can you please point him out by an article of clothing?
He's seated in the middle between the two gentlemen with a gold greenish tie.
Your Honor, let the record reflect the witness has positively identified the defendant.
Record so reflect.
Now, when you interviewed him, when you interview somebody, what's one of the first things you do?
Depending on the circumstances, in this case, it was to advise him of his Miranda rights.
Can you explain what those are?
Essentially, it's a set of rights that are guaranteed by the Constitution, afforded to anybody who's suspected of committing a crime.
And just so we're clear, did you read those rights to this defendant?
Yes, I did.
Did he agree to speak with you?
He did.
I want to focus on what he told you. Did he tell you about what happened?
Yes.
And did you have the opportunity to review the video yourself?
Yes, I did.
And was that video involving blue powder making contact with someone?
It was.
All right. And did you question the defendant about that?
Yes.
At any point, did he tell you if he encouraged that powder in any direction?
He did.
What did he say?
He said that he may have helped it along or encouraged it along in the direction of the individual.
Did he tell you how he did that?
He sort of pantomimed or did it at the same time, but he squeezed it as if he squeezed the bag and that he had walked in the general direction towards them.
Now, you used the term squeeze there. Is that a term that you said, or is that a term that he said?
He used that term.
Okay. Now, what about who approached who? Did he say anything about that?
He did.
That's true.
He did, sorry.
He did. What did he say about that?
He said in regards to the holy powder incident, that was, he said, to be fair, in regards to the holy powder incident, that was me approaching or walking towards their stairs. Something to that effect.
So during that statement,
yes,
did he say that the victim, John Gaffney, was walking towards him?
No.
Moment to confirm.
Yes.
Nothing further.
All right, any cross-examination?
Yes, Your Honor, thank you.
All right, Mr. Theophilopoulos.
Good afternoon, Detective Beaver.
Hello, sir.
Now, you claim you were called in to assist with the investigation. Who called you in?
A member of my command staff did.
Who was that?
Major Hasty.
Is Major Hastings the one that made the final determination in this case?
How do you mean, sir?
Whether or not to arrest?
No, sir.
And when you were called in, Mr. Aaron Levin Smith did not invoke his Miranda right to be silent, did he?
You're referring to Mr. Smith-Levin?
Yes.
Oh, okay.
I'm sorry, did I say it backwards?
Yes, sir.
My apologies. I don't want to confuse you.
No problem. No, he did not.
So normally, somebody who is under investigation can say, hey, I want my lawyer, and a jury never hears that, correct?
Potentially.
But Mr. Smith-Levin didn't say, I'm not talking to you, I want my lawyer. He told you what happened, correct?
Correct.
And did you watch the videos?
Yes, sir.
Did you see the water hitting the feet?
Yes, sir.
Of Mr. Smith-Levin?
Yes, sir.
Nothing further, thank you.
Any redirect?
Yes, Your Honor. Detective, when you say water hitting the feet, can you explain what that means?
Yes, sir. From what I saw in the video, the water was being poured at the ground and then it ran over and towards the feet of Mr. Smith-Levin.
Was Mr. Smith-Levin retreating?
He was not.
What was he saying?
He was telling the individuals to bring it.
Is that someone who is retreating or scared of that water hitting them?
Did not appear that way.
All right. You were also asked about Mr. Smith-Levin talking to you. Did he tell you what he intended to do that day?
Yes, sir.
What did he say to you?
That he was going to... I'm sorry, can you rephrase that? I'm sorry.
Yeah. In terms of what he intended to do earlier that day, what did he say to you?
That he was going to sort of create this entire situation, I guess, to protest.
Nothing further.
All right, can this witness be excused?
We'd like them to remain on standby, Your Honor.
All right, Detective, I'm going to advise you to step down. You need to stay in the courthouse. Do not discuss your testimony with anyone.
Yes, Your Honor.
All right, State, call your next witness.
Your Honor, at this time the State rests.
All right, can I have all the attorneys approach the bench, please? What's this, the defense?
Motion for judgment of acquittal this time. The first standard, this is a prima facie case. We argue the state has not met its burden, that there is clearly a scenario where the listed victim is walking down into the area that my client was constitutionally allowed to be in, at least per law enforcement saying that was the cutoff zone. Takes an action to throw water in the area that he is in, and it strikes him where he then throws the powder. Even the officer initially says that he was looking at this as mutual combat until he had a meeting with his supervisor. So I would argue that by law this should be a judgment of acquittal based on a lack of the state's ability to prove the battery occurred here in any way other than self-defense.
State.
The video speaks for itself. It's clear that Mr. Smith-Levin goes up towards the victim in this case. That we've heard from multiple witnesses that the victim did not approach Mr. Smith-Levin. He went up to him and threw the powder in his face. That at no point did the victim intend to throw any water. And in fact, Mr. Smith-Levin's own words is that in that moment, the water was not. you denied the motion.
I'm going to find the light most favorable to the non-moving party, that being the state, is that the state has set forth a prima facie case to bring before the jury. All right, tell me what you guys are going to do about witnesses at this point.
Cheryl.
Okay, why don't we put Cheryl on the stand, and then we'll break. I'll have to do my college with him anyway. Bless you. And then we will finalize the jury instruction so we can go from him. And if you guys are going to do any rebuttal, we'll go from there. Okay?
Agreed.
All right, thank you. Mr. Perlman, will the defense be calling any witnesses?
We will, Your Honor.
All right.
First will be Cheryl Fullerton.
Up here next to me, ma'am. Turn and face the clerk, raise your right hand, receive the oath, and answer loud and clear.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth? I do.
So over here, ma'am. Adjust the lights, speak in a loud, clear voice.
All right, Mr. Perlman, you may proceed.
Good afternoon, ma'am.
Good afternoon, sir.
Please state your full name and spell your last name for the record.
My full name is Cheryl Fullerton, Fullerton.
Okay. And Ms. Fullerton, how long have you lived in this area?
I've lived in Clearwater since July 2020.
Okay. Where did you live before that?
I lived in California.
Okay. For how long?
About 30 years.
Fair to say you have been protesting Scientology for many years?
Many years.
Okay. And how do you know Mr. Aaron Smith-Levin?
Aaron and I met protesting. We're both part of the our families of Scientology. So we just met protesting in the group, the community.
And obviously, on this particular day and time, you were present when this incident took place?
Oh, yes. Yes, that's me there, yeah.
Okay. And just for the record, the photo of Defense Exhibit 3 is up on the screen.
Yes.
You recognize yourself in the photo?
Yes, I'm the lady on the right in black.
Okay. Now, I just want to be clear. On this particular day, what are you doing? What is the objective of being out there?
It was a Tuesday. It wasn't a regular day. We usually go on Fridays, but we went on a Tuesday, and there was just the three of us. And we just go out, we do some chalking, we hold signs, we express ourselves, our First Amendment rights, and then we go home.
And this is a normal location where you protest on a regular basis?
Yes, we protest on the public side of the building.
Right. And to your knowledge, your understanding, there's that no trespassing sign by the rail and the grass, correct?
Yes, yes.
And that's kind of the cutoff as far as how the demonstrations go?
Yeah. We did our due diligence, so we know the boundaries of the property, so we're not ever trespassing.
Right. And you weren't on this particular day either, correct?
No, yeah. Right.
Now, I want to talk about the dynamic at play. You're out there, you're doing chalk. What are you doing on the ground? Like, what are you using, just so we're all clear?
It's children's chalk. It's what children used to do hopscotch. I don't know if that's American or English. It's just stuff that children, use to draw on the floor. It washes off with water.
Okay. Were you also using, you call it holy powder?
Oh, a holy powder, yeah.
Right.
In India, they have a springtime holiday called Holi, and they run around town. Everyone runs around town, all ages, covering each other in colored powder, which is cornstarch. It's the stuff that we put on babies' bottoms, basically.
Gotcha. And that's the powder that we're talking about in this particular case. So it's cornstarch. It's
safe for babies' bottoms.
Right. So the cornstarch. Why do you use the cornstarch?
Well, it just leaves a really good imprint when you're writing.
Okay. Were you doing anything that was permanent or could cause damage to any of
No, never. No. But no, we know that's not allowed, so we don't do that.
Okay. And you use cornstarch and you use the chalk regularly, correct?
Every week.
So this was totally the same thing you've done?
For 2 years.
Okay. Yeah. So on this particular day, is there kind of an escalation in the interactions between you and the church?
On this particular day, where before we were left alone to do our thing and just go home, that day, 3 or 4 gentlemen kept coming out with big wheelbarrows full of hot water, and I don't know if there's anything else in there. And they were throwing hot water on us. We were just protesting, walking around doing what we usually do, and they kept coming out of the building to throw hot water, to get the water on us.
Okay.
On us and our property.
Did you get wet in this situation?
Well, I tried to stay. I was wearing flip-flops, but I did try and stay away from it. But yeah, I did get wet, yeah.
Okay. And it's 3 or 4 times you believe that this occurred?
Yeah, but I believe it's about 3 times, because by the time this happened, I believe they already came out 2 other times, I think.
Okay.
They came out 2 other times and dumped water on us. And we asked them, like, don't do that. But they don't listen to us anyway. They don't look at us. They don't listen.
Do they even engage in anything?
No, never. No. They're not allowed. No.
So when they come out, and just to be clear, it was hot water, right, the first time?
Yes, it was hot water because I felt it on my foot.
Okay.
It was scalding.
Long story short, obviously we see a lot of it gets washed away. Is that correct?
Yeah, and the rain washes it away too, yeah. It just gets washed away.
Right. But I mean, right here, right now, even after maybe 1 or 2 soakings, clearly almost all of that had been cleaned out or washed out.
Yeah, it just runs off into the gutter, yeah.
Okay. Now, you guys put down, it looks like water barrier. Is that correct?
That day, yeah, because the week before they'd thrown water at us already. Okay. So we had the water barrier, so it wouldn't at least come on our property, on our area, on the public side.
Where you were keeping your stuff?
Where we had, our things.
Okay. And so they do that. Again, this is like, I guess, the second time this has ever happened, right?
Yeah.
So they keep doing the water thing. When they come out the 3rd time, okay, can you tell us from your memory, your recollection, what happens?
They came out once again. Some of them were wearing masks, and they were coming towards us, at us. Okay. We were standing on the property line, up by the volcano area there, and they just came at us with the big wheelbarrows of hot water.
Okay. And you stay where you're at. At a certain point, does Mr. Smith-Levin begin to walk over?
I believe, yeah. He was over by the end of the public area. He was just at the end. And the guy came through water on him, and I believe Aaron defended himself.
Okay. Did you see the water hit him?
Yeah.
Okay. And when the water hits him, is that when he throws the...
Yes.
You call it holy power,
the holy, syrup? Yeah, the cornstarch.
I keep saying syrup. Cornstarch.
Yeah, it's cornstarch, yeah. Okay. The holy powder, yeah.
The person then walks back up the stairs.
Yeah. Well, he turned around, and then he walked back upstairs, yeah.
Okay. Does he ever say anything?
No, he just stood there for a while looking at us and just walked back into the building.
Was there a point in time where they were coming down the stairs prior to that incident?
At other times, they had come out with water, but yeah, I couldn't really tell you how many. But I know that they had come at us before.
Right. Did they come? My question is, do you remember them coming down the stairs?
Oh yeah, coming down the stairs with buckets of water.
Right. And so again, they were out there doing that while you were there, no issues. And then on the 3rd time, Mr. Smith-Levin walks over. They dump from the top of the stairs, and then one person comes down. Right?
Yes, one person came down right next to him and threw the water at him.
And clearly, that individual saw Mr. Smith-Levin.
Oh yeah.
Clearly, he saw Mr. Smith-Levin continue to walk, near where he was at.
He was going right for him, right for Aaron. Yeah.
Right. And that person doesn't stop. Right.
No.
He throws that water, saying exactly where Mr. Smith-Levin's going to be.
Yeah. So Aaron defended himself, and I think it was reflex.
Was this planned? Were you guys staging this in some way?
No. We do this every week. We go out and we protest. Whoever comes out with us and protests.
So really what you plan is the protest you do?
Yeah. Basically, whoever has their signs, whoever has their chalk, come out and protest with us if you want.
Can you plan how Scientology security is going to react to you?
No. But we kind of know. I know.
Objection, Your Honor.
Sorry.
Motion.
Oops. Sustained.
Sorry.
On this given day, there was no plan involving security from Scientology, correct?
No.
Just one moment, Your Honor. I have no further questions, Your Honor.
All right, cross-examination?
Yes, Your Honor.
All right, Mr. Lechner?
Permission to approach clerk?
Yes.
And permission to publish on Mr. Bell?
Yes.
Ms. Fullerton, you know Mr. Smith-Levin.
Yes.
So I think you just said that you're friends with him.
Well, I've known him for 2 years.
So you're friends with him.
I guess you would say that.
Okay. Well, are you or are you not?
I know him. Yeah, we're friends.
Okay. Of course, you don't want to see your friend be convicted.
Well, no.
Right.
No.
So you're testifying for him.
Yeah.
Okay. Now, this whole incident on July 29th, 2025, you were there.
Yes, sir.
The defendant was there.
Yes, sir.
Right. And you were actually basically in that same kind of spot as the defendant, the same area.
In the same area, yes.
Right.
In front of, yeah. In front
Right.
of the
So
building.
you saw everything that happened that day.
Yes.
Let's watch the video.
Jamie.
I got you, by the way.
Let's get ready to party, baby. Come on, bring it. Bring it. Bring it.
Now, Ms. Fullerton, you just told us that it was hot water.
Yes, it was.
Scalding water.
It was hot.
And yet he just stands there.
Well, he's wearing tennis shoes. I was wearing flip-flops.
Oh.
So the water touched me on my actual skin.
Okay, but it didn't harm Mr. Smith-Levin.
Oh, I don't know, but...
So it might have harmed you, but you can't say if it harmed Mr. Smith-Levin.
Right.
Okay.
But water touched him.
His shoes.
Sorry?
His shoes.
Yeah.
Okay. All right. And actually...
It's just going to hit our water barrier, you losers. Yeah. Here you go.
Now, you made a statement on direct examination that they're coming towards us.
Mm-hmm.
They're at the top of the stairs?
They're coming out of the building towards us.
They're at the top of the stairs?
Right, they're at the top of the stairs. They come out of the building towards us.
They don't go down the stairs?
Right, but they come out of the building towards us.
Well, in order to come farther towards you, they have to come down the stairs.
Okay.
You do not know?
No, fine.
Fine. So yes.
Yeah.
Okay.
They came out of the building towards us.
And stayed at the top of the
We
stairs.
don't bother them ever.
You okay? Can you read that over this me?
Oh, it's just going to hit up.
Now, you also made a comment that they went right for Aaron.
Well, the gentleman was walking towards Aaron. He was on this side. He was going to throw the water at him.
Oh, so that gentleman came all the way out to that mosaic.
Well, other times they just came to the front. This time I see him. He was walking to the end of to the side of the staircase.
So what we're actually here for today, they don't come out to that mosaic in this video.
Oh, to the volcano thing? No.
Right. In fact, Mr. Smith-Levin goes up to him.
Right.
Right. So it's Mr. Smith-Levin who approaches the victim.
They approached us first, though. They came out of the building.
Well, Ms. Fullerton, you just told us.
Oh, okay. Oh, I see. All right.
So Mr. Smith-Levin
Right.
approached the victim. Correct?
I don't see him approaching the victim there.
Don't play the video.
Water barrier, you losers. Yeah. Here you go.
So your testimony is he didn't approach the victim?
I didn't say that, but I can see there now. At the point you had shown me, it didn't. But now I can see. The gentleman came out. When you're standing there, it's different. It's not like watching it on video. He came out to the side towards us. The other gentleman just came out to the front. And that's what they were doing. This time he came to the side.
So he didn't come directly at Mr.
But he didn't come down the stairs.
Ms. Fullerton, that's not my question.
Oh, sorry.
He didn't come directly at Mr. Smith-Levin.
I guess not. No.
In fact, what you just said is it helps to be there looking at it, right?
Yeah, it's different when you're there.
Right, it's different when you're there. It helps when you actually see it. Right? Is that a yes?
Yeah. Yeah.
You also made a comment about that holly powder, the chalk, the blue, whatever. That it's a really good imprint when you're writing. You made that comment on direct.
It's bright. The colors are bright.
Well,
yeah.
The comment you made on direct was it makes a really good imprint when you're writing, correct?
Yeah.
So your purpose was to have it stay there.
No, it doesn't stay there. It's washable. It doesn't stay there. We write the words, and with the wind, it blows the powder off.
Mm-hmm. But it makes a good imprint.
They're throwing down water. It's going to stay a little longer.
Ms. Fullerton, that's not my question.
Okay.
My question is,
doesn't
it makes a good imprint.
It doesn't imprint like a printing press. It's just powder that lays on the ground. The wind itself blows it away, and the water washes it away.
I understand you're saying that now.
It doesn't imprint like a printing press. That's not what I meant.
Oh, so...
It just makes good writing.
So you were wrong to say that on direct?
Wrong. Well, maybe I used the wrong word, but I meant it when we're writing, it's very bright and colorful. It's very easy to see, and that's why we use it.
No further questions, Your Honor.
Thank you.
Any redirect?
Man, you were just cross-examined on being friends with Mr. Smith-Levin. Did you come here and lie for him in any way?
Never, no.
Right.
I wouldn't do that. I'm in a court of law under oath.
Right. He's standing there in this video. And again, we don't have the context of the first two times they come out, correct? We didn't see what they do those first two rounds, right?
Exactly.
So this is round 3 of whatever the objective is for them. And at the end of the day, is Mr. Smith-Levin standing there for a reason where he's at?
Yeah, it's the public area. It's the public part of the street.
Right. And is he standing there, hoping nobody comes down to try and prevent them from walking down any further?
Pretty much.
And then the guy who comes down the stairs, at the end of the day, he comes down the stairs, right?
He does.
Right.
Mr.
Smith, you can hear in the video, he's like, okay, come on, let's go. He walks down those stairs, right? Doesn't stop, doesn't back away, none of that, right?
I'm going to object to leading, Your Honor.
Sustain.
Nothing further, Your Honor.
All right, may this witness be excused?
We'll have her stand by, Your Honor.
All right, I'm going to advise you need to step down, stay in the courthouse, do not discuss your testimony with anyone. All right, thank you.
Yes, Your Honor, thank you.
All right, ladies and gentlemen, at this time I need to take a legal break, so I'm going to break us for about 15 minutes. This is usually the time that if I'm going to make an error on how long you guys are going to be out, it's this time, because I have to take care of some legal issues. But we're going to try for 15 minutes till 5 o'clock. It might be a couple minutes after that, but I will move things along as quickly as I can. Same thing, close your pad. Do not discuss this case amongst yourselves.
Keep your pads and pins on the chairs and follow me, please.
Oh, careful. Yeah, I see that.
Your Honor, the jury's out of here to the court.
All right, so it's my understanding, Mr. Perlman, at this time that Mr. Smith-Levin may decide to testify?
That is correct.
All right, do y'all need to have any conversation outside before his final decision to testify?
I don't believe so, Your Honor.
All right, if you'll stand and raise your right hand for me, Mr. Smith-Levin. Swear and affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead and put your hand down. Mr. Smith-Levin, do you understand that you have two rights as being a defendant in a case when it comes to testifying? You can testify, and if you testify, your testimony will be weighed by the same as all other witnesses that testify. Do you understand that?
I do.
And you also have a right not to testify, and if you choose not to testify, that cannot be used against you. Do you understand that? Okay, I'm going through a colloquy with you, so I got to make sure you understand everything, okay? All All right, have you had an opportunity to speak with your attorneys, Mr. Perlman and/or Mr. Theophilopoulos, in regards to whether you're going to testify?
Yes.
And do you understand that your attorneys are here only as it relates to your decision to testify to give you guidance?
Yes.
And the decision to testify is your decision, no one else's decision?
Yes.
Has anyone, my understanding is you had made a decision that you are going to testify, is that correct?
That is correct.
Has anyone forced you to testify?
No.
Is your decision to testify made freely and voluntarily?
It is.
All right, I'm going to find, based on my colloquy with you, that you have made a free and voluntary decision to testify in this matter.
That's correct.
All right, well, we got a few minutes. Let's go ahead and finalize the jury instructions so that we can move into closings when we get done. At this point, I'm looking at starting off at 2.7. Give me 1 second.
You're at 2.7 now?
2.7, closing argument.
Yes.
Give me a second.
It's at this exact moment I'm happy we do these Friday before the trial.
I'm sorry, what?
It's at this exact moment I'm happy you do these on Friday. before
Yeah,
trial.
me too, because I do not like my time, everybody's time
Right, an hour and a half
wasted.
later.
Yeah, Tracy gets them all set up and then I finalize them. All right, so 2.7, closing argument, everybody in agreement that stays the same?
Yes, Your Honor.
All right. 3.1, introduction and final instructions, everybody agrees that that stays the same?
Yes, Your Honor.
Yes, Your Honor.
3.2, statement of the charge, everybody agrees that stays the same?
Yes, Your Honor.
8.3, battery, everybody agrees the changes that I made are what we agreed to on last Friday?
They are.
And nothing changes, everybody in agreement?
Your Honor, the state would ask that we do include the additional instruction that is just below number 2 in the standard, where an intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act.
It is.
Oh, sorry. And then, sorry, I didn't see that part. And then the state would also be seeking a battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person, for the purpose of, if the jury were to find that the contact was made just simply with the outer clothing of the defendant, that would be reason for that instruction to be included.
You're already ruled.
Right, we didn't have the discussion about the clothing part of it, though. I need to pull up the standard. Oh, wait, I got it right here. Why am I looking at it up here? Good old-fashioned paper always sometimes works better. Okay, talking about the next section, a battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, the object that is touched or struck must have such an intimate connection with the person that it is to be regarded as part of or an extension of the person. I actually agree with the state in regards to the clothing aspect of it. It would have been easier if y'all had made that argument the other day, so I didn't have to worry about typing that in. See if I can find the instructions.
Yeah, we have no objection. We're in as well.
Okay, let me just get the instruction. Tracy, under Smith-Levin, under 8.3, I need you to add the section about a battery may be found as a result of the intentional touching or striking. Make sure the font is the same. All right, so we'll make that change. 3.6, justifiable use of non-deadly force. Everybody agrees that that stays the same?
Yes, sir.
Okay. Uh, 3.7, plea of not guilty, reasonable doubt and burden of proof. Everybody agrees that stays the same?
Yes, sir.
3.9, weighing the evidence. I'm going to make the change there about the defendant is going to testify. Where's the highlight on that? Hold on. I'm going to take out that highlighted part that gives only if defendant testified. Taking that out. And then 3.9A, defendant not testifying. Just take that out of your instructions. I won't be giving that. Madam Clerk, can you create the verdict form for me, please? Just a simple one. Guilty or not guilty of battery.
Yes, ma'am.
Defendant not testify. Okay, we talked about that. The next one I have is 2.2, instructions on edited recording. Is that instruction needed?
Yes, Your Honor.
Everybody in agreement?
That's fine.
All right. 310, rules for deliberation. Everybody in agreement that that doesn't change?
Yes, Your Honor.
All right. In agreement. 311, cautionary instruction. Everybody agrees that doesn't change?
Yes, sir.
312, verdict. Everybody agrees that that doesn't change? 313, submitting case to the jury. Everybody agrees that doesn't change?
Yes, Your Honor.
All right, Tracy, I'm getting out of the jury instructions so you can make that change to the battery one. All right, Madam Clerk, do you have the verdict form?
Yes.
Can I see it, please? No. Tracy, it would be take that one out that says assault and just see. Okay. All right, I'm going to step down and make sure Tracy's making the proper change here. Madam Clerk is correcting the verdict form. When she finishes doing that, look at the verdict form, make sure nobody has any objections to it, and I will be right back.
For some recess.
Awesome. Should I tell everyone if anyone needs the bathroom outside?
I'm in and out, but
Yeah,
less than
never mind.
5 minutes, so it's y'all's decision.
Anyone wants to use the restroom, I'll find it. See you that day. If you do it.
Jury's present, seated, and adjourned.
All right, see, I was right. This is the time I ran a little bit late. So have a seat, everyone. And Mr. Perlman, will the defense be calling any other witnesses?
We will call one more witness, Your Honor.
All right, go ahead.
Mr. Aaron Smith-Levin.
All right, come on up.
Over here, please. Now, right next to me. Turn and face the clerk. Raise your right hand and receive the oath. And sir, last thing I do.
Swear or affirm to tell the truth, the whole truth, and nothing but the truth.
And you. Step over here, please. Have a seat. Just a mic. Speak with loud for the voice.
All right, for the record, Mr. Theophilopoulos.
Thank you, Your Honor. Please state your name for the record.
Name is Aaron Smith-Levin.
How old are you?
45.
And what city do you live in?
Clearwater, Florida.
And how long have you lived in Clearwater?
This most recently about 20 years.
Prior to Clearwater, where did you live?
How far back do we want to go?
Philadelphia.
Okay. I grew up in the Philadelphia area in the suburbs of Philadelphia.
And did you work in Philadelphia as a child?
At the age of 12, I started working full-time for Scientology.
Objection, Your Honor. Motion.
Approach. Really, right out of the box, you violate my motion limiting?
How is that a violation?
Because we specifically said any prior acts that he had with them was not coming in. No. I specifically said that. I said the only thing that was going to come in was that he protests them and that he has, what do you call it, a YouTube video stuff that he does. But I specifically and categorically said nothing about his past was coming in with them because there's no way to prove it or disprove it, and I was not having a trial about his relationship with the Church of Scientology. I made that abundantly clear and held hostage his motion to travel for that very reason, to make sure this motion limiting was not violated. So there will be no more conversation with him about it. It was even brought up before trial, where he was saying that the minute the door was opened, he was going to talk about his connection to the Church of Scientology.
I'm the one that asked the question.
I get it, and you were not supposed to.
I had no intention of violating. I just wanted to show that he was involved since age 12.
Which we made it very clear that was not going to get into it. I couldn't have been more clear.
It was the abuse that we talked about.
No, nothing. That nothing was coming in about any prior history that he had with them, other than the fact.
I interpreted it as the
I couldn't have been, okay, Mr. Theophilopoulos, you're a very good lawyer, and I was extremely clear. I cannot be more clear than I was that day, down to the point that I was holding his motion to travel hostage over this particular issue. I made it clear about that. So we're done. You're not going to ask him any more about it, and there will be no argument about it.
Understood.
Are you currently a Scientologist?
I am not any longer.
Objection. Motion.
Overruled at this point. We're going to move on.
I want to ask you, what do you do for work?
I mainly run my YouTube channel. Am I allowed to say what it's called?
You can say the name of it.
I'm going to object to that, Your Honor.
Approach. What is the name of the YouTube channel? I'm sorry.
Growing Up In Scientology.
Right?
It's SPTV Foundation.
Come on.
YouTube channels. Growing Up In Scientology.
All right, well, one saying one thing, one saying the other. And if you don't know what the answer to this question is going to be, don't ask it.
I've got the answer. SPTV Foundation.
Then you're going to ask him and say, is it called? That one leading question.
Yes.
No.
Your YouTube, is it SPTV Foundation?
Oh, I see. My YouTube is colloquially called, my channel is colloquially called SPTV. Separately, I run a nonprofit foundation called the SPTV Foundation.
Let me ask you with regards to the 215 South Fort Harrison address. Are you familiar with that address?
I'm very familiar with it.
How is it that you're familiar with it?
It's basically the largest Scientology building
in the world on the largest Scientology base in the world. It's called the Flag Building or the Superpower Building.
And have you been protesting in that area? Tell us.
I've been protesting there every single week for a couple years, and yes, protesting in general for about 10 years.
And what type of props do you and others use to protest at that site?
We've got a few different types of materials that we use. We have signs, just protest signs. We have some cardboard cutouts of some famous Scientologists like Tom Cruise and John Travolta. We have a cutout of the leader of Scientology, David Miscavige, and we have basically chalk. We use kids' fun run powder and like kids' sidewalk chalk, and then some like spray chalk. That's most of our materials.
The chalks and the spray chalks and the fun run powder, are any of those permanent in nature where they stain anything?
No, they all easily wash off with water.
And I want to take you to July 29th, 2025. Do you recall that date?
I do.
And do you recall what time you went to 215 South Fort Harrison? Approximately.
4 or 5 in the afternoon, something like that.
Who was with you?
My friend Cheryl Fullerton and Jamie Castro.
And what was the purpose of being there?
It was a normal protest for us. Usually our protests are on Friday. I think, if I recall correctly, we were just getting an extra day in. But yeah, it's a normal protest.
And who was utilizing the chalk and the powder?
We generally are all utilizing the chalk. Maybe at that time I was doing it more.
Were police at one point in time called out there to look things over?
That's what they told me. I didn't observe them. Like Officer Frost, who had testified earlier, he said he'd already come out a few times. And
did you see him at all?
He said he just drove by. He didn't get out of his car.
Okay.
But the police are called on as
Objection. Impermissible character evidence, relevance, 403.
I'm going to sustain it for relevance.
Let me show you what is marked as Defense Exhibit 3. Is that 3? Thank you. Do you see on the far right where the lamppost is, who is that? It'll pull up.
Am I allowed to stand?
Your Honor, may he?
Yes.
Oh, are you here?
Yes. Who is that?
I mean, I now believe that is John Gaffney. I had no idea who it was at the time.
And do you know who the individual in the middle is with the black suit?
I don't know any of these people.
Okay, what about the other individual with a mask on as well, white shirt, black tie to the left?
Don't know any of them, never met any of them, couldn't pick them out of the lineup.
Were these individuals attempting, well, what were they doing? Why were they out from the building?
They were harassing and intimidating.
Objection, speculation.
Overruled.
You can say that again, I'm sorry.
They're harassing and intimidating protesters. It's not their job to clean the ground.
And were they using buckets, and what was in the buckets?
It was water. In the beginning, it was hot water.
Let me ask you about the black line that you can see. It's like a barrier of some sort. What is that?
That is a water-activated water barrier that I brought to the protest.
Can you point to it? Okay. And what is the purpose of that water barrier placed in that area on that date and time?
It was to counter what the security guards had recently started doing, which was instead of waiting until we leave to come out and clean up the chalk every Friday night, they started coming out and just pouring the water on us
and
confronting us.
And you also see the large letters on the red brick. What did that say?
That said cult.
And was that barrier also placed there to protect that, or?
It's actually the reason it was there. And if I may?
Yes.
There's a reason the barrier is placed. See, this photo was taken earlier in the protest. Every time they would step over our barrier to dump water on our art, we would move our water barrier closer and further and further away from their property line. Because never before...
Objection, impermissible character evidence.
Speaking to my experience.
Okay, you sit.
I'm sorry.
When there's an objection, you keep your mouth shut.
No problem, Your Honor. I understand.
All right. What's the ground for your objection?
Impermissible character evidence as to specific acts.
All right. I'm going to overrule at this point. I'm going to give some leeway. Mr. Smith-Levin,
Yeah.
you are to answer the questions from your lawyer. That is it. You're not here to give speeches and you're not here to give a narrative. Do you understand?
Yeah.
And when an objection is made, you do not interrupt on it and you do not respond to it. Do you understand that?
Yeah.
Thank you. All right, go ahead, Mr. Theophilopoulos.
So we left off talking about the barrier
Yes.
and the purpose of it.
It was to protect our art.
The water, as you saw in the video, when it is dumped from the stairs and goes down, where does it end up?
All the way on the public sidewalk in the brick and everything.
So this is Defense Exhibit 1. Do you see water that's flowing through?
Absolutely.
And where did that water come from?
It came from them walking up to where we were, not on their stairs. It came from them walking all the way up there with about 6 to 8 big 5-gallon buckets of water and dumping it right on us. I had to reapply that chalk, which is why you see that word.
So there were members of Scientology that actually, were there members of Scientology that actually came out with buckets and tried to take the word cult out of there?
Absolutely, they did.
And is this the first time water was used?
This day?
Yes.
No.
And tell us about the water. First of all, what kind of shoes are you wearing in that picture? Can you tell?
In this picture, I'm wearing just a very lightweight Nike running shoe.
And did your shoes get wet?
Absolutely.
Describe what happened with the water that was poured.
Well, the Sea Org members, the Scientology security guards, would come up to us carrying a 5-gallon bucket in each hand, and they would walk right up to where we were and dump it on the ground. And it would get our feet wet, and it would get the chalk wet, and it would ruin the art, and get our bags wet, etc.
Now, at any point in time, did any of y'all try to protect your messages on the public property?
Well, that's the purpose of the water barrier.
What about moving in front of the members of Scientology?
No,
Do you recall?
Well, we're not going to make physical contact with them.
Okay.
Yeah.
And you saw the video when Mr. Gaffney was walking. Did you see his route?
Yes.
And I'm talking about the third and final time.
That's right.
What direction did he walk?
He walked to the side of the stairs and down the stairs.
And did you also go towards him?
As he approached me, I approached him.
Okay. And you made some statements. You heard him.
Yeah.
What was your? Why were you approaching him when he was approaching?
Because I was done being bullied and harassed and intimidated by these Scientology agents while we're engaging in constitutionally protected activity on public property and not escalating anything with them.
And was the water dumped first, or was the powder dumped first?
Oh, the water was absolutely dumped first, not only in that incident, but for the entire protest.
You saw Mr. Gaffney's movement. Describe it prior to the water being dumped.
Well, I remember the group of security guards coming out the door, standing almost military style at the top of the stairs. They then dumped the mini dumpsters of water, and then, see, we don't go up those stairs. We're told we can go to the stairs, but not up the stairs. But I was ready. I was sick and tired of being intimidated and bullied by these guys all day. I said, if this happens again, I'm going to defend myself and stand my ground. So I saw him break away from the pack. I saw him come down the stairs. I said, okay. And then I might have said, let's go or whatever. And then I walked up to him. He pulled the bucket back. He threw it, and I threw the powder.
Why'd you throw the powder?
It was in self-defense. It was in defense of further aggressive action from these Scientology agents.
And what was that powder, the blue powder, made out of?
It's kids' fun run powder. It's the stuff you're supposed to blast people in the face with while they're running 5Ks. It's cornstarch.
Now, at some point in time, law enforcement shows up, correct?
Correct.
Who was that?
It was Officer Frost and Officer Reich.
Let me take a step back. The first time water's poured, did it hit your feet?
Every single time it was poured, it hit my feet.
Was the first round of water hot or cold?
The first round was hot. To my recollection, the first round was hot. I don't remember it after that.
Okay, you don't remember the second or third, if it was hot or cold?
I feel like by memory, I can say the first round was hot, and that's what I'm not willing to make that same claim for the later rounds.
And when that water hit your feet, did it soak your shoes?
Absolutely.
Did you want hot water or cold water later on your feet?
No, that contact was unwanted.
Did you ask for it?
I did not.
And let's talk about Officer Frost. At some point in time, did he come on scene?
He did, yes.
And did you show him anything?
Yes, I showed him my live stream video several times, and then, I'll just answer the question. I'll wait for you to ask.
How many times do you think you and Officer Frost looked at the video?
I would say at least 3 times.
What happened after that with Officer Frost?
He came over to me after conferring with someone, explained to me them throwing the water at our feet was a battery, me having thrown the powder at the guard was a battery. He was just going to write this up as a mutual battery. He was not going to make any arrests. We had a little bit of a further conversation about, okay, I just want to make sure that my complaint's going to be sent to the state attorney as well. He said, absolutely.
Your Honor.
Sustained.
And did things change later?
Yeah, about 10 minutes later. It feels 10 or 15 minutes later, yeah.
And what, as far as physically, what happened?
He called me over and said, hey, can I show you something? And then he showed me the video, and he said basically that...
Objection, hearsay.
Oh, okay.
Oh.
He basically explained that upon further review, his opinion was that I was the only one who committed a battery, because in his opinion, you know, the last piece of water was technically not maybe thrown directly at me. It didn't make any sense to me at the time, and I didn't even understand that he was explaining to me that I was under arrest.
And did he inform you that he had to talk to a supervisor?
He actually informed me of that fact after I was arrested, and we were transported to the police station. We sat outside the police station for about 20 minutes in the car while he made some calls to his superiors trying to get permission not to arrest me.
Now, when they read you Miranda, you have a right to remain silent. Anything you say can and will be used against you. You have a right to a lawyer. Did you tell them, I don't want to talk to you?
I told them I'm happy to tell them everything. I had already live streamed it all on YouTube. I'd done nothing wrong. I was defending myself. I was standing my ground, and it was I said it was a mutual battery, according to the police officer himself.
And the live stream, is that your footage that was occurring as things occurred?
I was one of the people live streaming, so it was on my channel. It was also on at least one other channel.
May I have a moment, Your Honor?
Yes.
Based on everything you observed and saw and what happened to you, did you feel as though you had the right to be at that location and defend yourself?
Absolutely.
Nothing further.
Any cross-examination?
Yes, Your Honor.
Mr. Lechner?
I think it's late afternoon. Good late afternoon, Mr. Smith-Levin. How are you doing today?
Good.
All right. Now, I think we can all agree on some basic facts here. So, you were out protesting July 29th, 2022.
That's correct.
Right. The video we saw earlier, you were in it.
That is correct.
Cheryl Fullerton was in it.
Cheryl Fullerton was in the video.
John Gaffney was in it.
That's correct.
Everyone that testified today, excluding Officer Reich and Detective Bieber, was in the video today.
I think that's correct.
Okay. And you don't deny that you're the one holding the blue powder.
That is also correct.
Okay. You also don't deny that you've been charged with battery.
I have been charged with the battery, yeah.
And that you're testifying here today?
I am testifying here today.
Right, because of course you don't want to be found guilty.
I definitely do not want to be found guilty.
Right. Now, I want to start right before the incident, because you mentioned a couple times, I think it was 3 water incidents?
Yeah.
Right. And I want to focus on that second one. That was about 25 minutes before the video we've shown today a couple times.
That sounds about right.
Right. And in that, you actually said they're more than welcome to keep coming out.
Well, they are more than welcome to keep coming out. It doesn't mean it's legal, but they're more than welcome to do it because we're there engaging in constitutionally protected activity.
Right, but that's what you said.
I'll take your word for it. You can play the video if you'd like. I don't remember.
Oh, okay. You don't remember now?
You can play the video.
All right. Well, that was minutes after they poured water on the ground.
Is that a question?
Yeah.
If you want me to, I don't recall the video specifically. You're welcome to play
You
it.
recall the water incident about 25 minutes before the video we're all here for.
I recall there were 3 separate water incidents.
Correct, and we're talking about the second.
I now recall that there were 3 total.
Right. So we're talking about the second.
All right.
Okay. In that one, you stated on direct examination they came over the water barrier.
I believe in both the first and the second they came over the water barrier.
That's okay, Mr. Smith-Levin. But in the second one, you stated on direct examination they came over the water barrier.
Okay.
That's what you said.
Okay.
You also specifically said, and I quote, they came over to dump it on the ground.
Okay.
That's what you said on direct, right?
If you say so.
If I say, you don't remember?
If you want to play it back for me.
The direct examination. You
Objection, asked and answered 3 times.
Well, it's cross-examination, but how about we go in argumentative and move it on?
Yes, Your Honor. Now, before or after the second incident, before the third incident, you with me?
I'm hearing you.
Do you not know what I'm talking about, Mr. Smith-Levin?
Well, we're talking about the incidents that I'm being charged with.
Correct. And
Sure.
on direct examination, you talked about 3 separate incidents.
I do recall talking about 3 separate incidents.
Okay. After the second incident, the Scientologists went back into the building.
That makes sense?
You were still out there.
Of course.
Fullerton was still out there.
Yes.
You had an idea to go to your car.
I think you might be getting the sequence mixed up.
Oh, I don't think I am, Mr. Smith.
Well, if you'd like to play the video, you can play the video.
Okay, I need everybody to stop. I'm going to instruct you again, Mr. Smith-Levin.
Mm-hmm.
You are not to be argumentative, and you are to answer the questions. Do you understand?
I do understand.
Your attorney has the right to follow up and ask you any follow-up questions. Okay? You are to answer the questions you are being asked. Mr. Lechner, you have a right to ask a question more than once because it is cross-examination, and you know that. But stop the argumentative aspect of it.
Yes,
it is
Your Honor.
5:30.
Yes.
I want this case over, and so does this jury.
Yes, Your
so
Honor.
hit your points and move on.
Yes, Your Honor. You went to your vehicle at some point.
I do not recall that.
Would it help if you saw a video?
It certainly would.
All right. Permission to approach the witness, Your Honor?
Yes.
May I approach as well, Your Honor?
Yes.
I do remember that.
So now you remember.
I do, yeah.
You remember going to your car.
I do remember going to my car.
And you just reviewed that video with myself in defense, correct?
That's right.
That was you on the video?
That was me on the video.
All right, that was you talking on the video. And then that accurately depicted a video of you on July 29th, 2025.
It did, yeah.
Your Honor, at this time, the state would mark this as States 4 and offer it into evidence.
May we approach?
Yes. Yes.
Yes, Your Honor.
What's your objection?
What is the predicate for it? For what purpose?
No, he just set the predicate, so what's the reason for it?
Your Honor, he refers to him coming to believe that he knows what they're about to do and that he's getting his secret weapon.
All right, I'm going to overrule the objection.
Opposed?
Mm-hmm.
Sorry, Your Honor, technical difficulties.
Actually, I've got a really good idea. Okay. I have a feeling I know what's about to happen. All right. You guys ready? We got a secret weapon. That's right.
Right, Mr. Smith-Levin.
Yeah.
You said that you had a secret weapon.
That's right.
You then went, after that video, you go back to the pavilion area.
Yeah. That was more of the same chalk we were already using.
But you went back to get, in your own words, your secret weapon.
After I said, I think I know what's about to happen.
And you said your secret weapon.
That's right. More chalk. More powder.
Now, you started spreading the blue chalk around the ground.
At what point?
After you got back. You started spreading
I'll
the
take
blue
your word
chalk
for it.
around the ground.
I'll have to take your word for it.
Do you need to see the video?
If you're asking me to comment on the record, then yeah.
All right. Can you please take one? While Ms. Mead is preparing that manifest clerk.
Yes, Madam Clerk, that needs to be marked as State's Exhibit number 4. I don't think it was pre-marked.
Get ready to party. Jamie. So you're standing in the pavilion right here.
That doesn't show what you just said it was going to show.
Standing in the pavilion right here.
That's not a pavilion.
You were standing in the circle right there.
Correct.
Okay. You were standing. You had just got done finished with, I don't know if it was a broom, squeegee, what it was, but some type of thing spreading the blue chalk.
Before I went to the car?
Mr. Smith-Levin, after you went to the car, or you are in there?
I said, I'll take your word for it unless you want to show me the video.
Now, you see 4 people exit the flag building.
Yes.
Okay. And you see them carrying, for lack of a better term, bins of water.
Well, they're not carrying them. They're pushing them because they're too heavy to carry.
Okay, Mr. Smith-Levin. You see them dump that water.
I saw them dump it right at me, yes.
Right at you. Miss Nick, can you play the video?
Thank you, by the way.
Let's get ready to party, baby. Come on, bring it. Bring it. Bring it.
It's literally dropped right at me.
It's just gonna hit up.
Literally just hit my feet.
Did I ask the question?
You've asked many questions.
Again, Mr. Smith-Levin, you are to answer the questions that are asked of you. You are not to comment in between questions. Your attorney can follow up anything.
Understood, Your Honor.
Follow up.
I'm sorry.
I know, but I told you 3 times.
I apologize. I've never done this before. I apologize.
Now, you said they dumped water on you.
Directly at me, I said.
At me, right. You didn't say, stop, don't do that.
No, I didn't say stop.
No, you didn't. Exactly. You said, let's get ready to party.
They've already been dumping it on us for weeks.
That's not my question. My question is, you said, let's get ready to party.
I did say that.
Right, while you're holding blue chalk.
That's right. I was ready to defend myself.
Right. And actually, what you said is that you're ready to party with chalk you said on direct is used in fun runs.
It is used in fun runs.
Okay.
Yeah.
Now, you also said, bring it 3 times.
Okay.
By okay. Yes, you said that 3 times?
Are you asking me to say specifically that I said it 3 times? Because I'll take your word for it unless you want to play the video.
Did you not just listen to the video?
I didn't count how many times I said it. Does it matter?
Okay, Mr. Smith-Levin. Now, there isn't, when you said that, you obviously weren't facing the people behind you. It's a yes or no question.
Can you ask me the question?
Sure. When you said, bring it, you weren't facing behind you.
That sounds like a statement. I'm not trying to be difficult here. Like, ask me a question, and I'll be happy to answer the question.
That was a question. Answer the question.
Well, one more time. Just give me the question.
When you said, bring it.
Yeah.
You were not talking to the people behind you.
No, I was speaking to the people that was about to dump water on us again.
Correct. You were speaking to the people that includes John Gaffney.
I mean, I know now that it includes John Gaffney.
Right.
Yeah.
Thank you for saying that, Mr. Smith-Levin, because at the time, you had no idea who he was.
No, I don't know who any of these people are.
Right.
Yeah.
So okay. Now, Mr. Gaffney, he starts to walk down those steps at one point.
That's true.
Right. Now, right here in this still shot, you're not quite in the middle, but you're not really in the edge of that circle either.
Okay.
We can agree on that?
I'm standing slightly to the left of the tip of the volcano.
Correct, right. So not right in the middle, but also not on the edge.
I'm standing to the left of the tip of the volcano.
Okay. And when he starts to go down those steps, you don't stay there.
No. When he starts approaching me, I approach him.
Okay. So yeah, you actually take, I believe it was 5 or 6 steps.
I don't know the number of steps.
You took multiple steps.
I took multiple steps toward him when he was walking towards me.
Miss Me, can you play the video? Waterbury, you losers. Yeah. Here you go. You said, now on direct examination, you said, I might have said, let's go. That's what you said on direct.
I'll take it. Okay.
But on the video, you said, here you go.
Okay.
We can agree that's different.
Oh, I said more than one thing. I think I said more than here you go, didn't I?
Oh, so the microphone, it didn't catch the other things you said? Is that your testimony?
No, I'm saying I said multiple things there, didn't I not? In the whole 15-second interaction or whatever?
Right, and we're going to watch the rest of that interaction. Actually, Miss Me, why don't you do it?
No, I mean earlier.
I got everybody in it, by the way.
Yeah. Come on, bring it back. Come on back, baby. You state, bring it back.
Yeah.
So you want him to come back to you.
Well, I was being brash. But I was dead set on defending myself against the hostile and aggressive action by the Scientology
So
agents.
much that you wanted him to come back.
I mean, I was being brash.
Okay.
Yeah.
Ms. Bing, could you play the rest of the video, please?
What? Did you want some more? Come on, we can play. Did you want some more, buddy? Come on, let's go. We can play. We can play. Let's go. Come on, we can play.
Now, you also talked to law enforcement that day.
That is correct.
Right. And one of the first people from law enforcement you talked to was Officer Frost.
I believe that is correct.
Right. And you specifically told him that the victim got battered by chalk blowing in the wind.
That is true.
So that's what you said?
Well, that is what happened.
I'm not asking if it's what happened.
Oh.
I'm asking if you said it.
That sounds like something I would have said. I don't have a clear recall of a conversation that happened 8 months ago.
Well, do you have a clear recall of what happened earlier in today's trial?
I mean, it's clear as a reasonable person could have.
Right. You were here when Officer Frost testified.
Well, that's what he testified. That doesn't mean that's what occurred.
Okay.
Yeah.
Now, you also talked to the detective we saw earlier today.
Detective Bieber.
Right.
That's right.
And of course, you remember what he testified to.
I think I do.
How you said to him
Yeah.
that you squeezed the bag of powder.
Oh, well, that's what he said. I don't know if that's what I said.
You don't know if that's what you said?
It was 8 months ago. It was 8 months ago, the first time I'd ever been arrested in my life. My adrenaline is through the roof, and then I'm having an adrenaline dump at the police station. I feel like I have a general recollection of my conversation, but I can't swear to specific words that you're asking me.
Right.
Yeah.
You can swear to something that happened 8 months ago in front of this jury as to your intentions, but not what you said. That's your testimony.
Oh, I can absolutely testify to my intentions from 8 months ago.
Just not what you said.
Well, it depends what we're talking about.
Now, you told him you might have encouraged it to go in his general direction.
I clearly encouraged it to go in his general direction. That's obvious in the video. My goal was to defend myself against the ongoing hostile action by these Scientology agents who are harassing and intimidating protesters, not just this day, but for weeks and weeks and weeks. And that's why I said, I think I know what's about to happen, which means I think they're about to come out again. And I'm not willing to continue to be harassed and bullied by these masked thugs working for the organization that I grew up in.
Are you done?
Yeah.
Okay. Let's get back to my questions. So, in this video, you throw the powder on John Gaffney.
I throw it in his direction.
And it makes contact with him.
I saw that some got on his back in those photos they showed earlier.
So some made contact with him.
It looks like some of the powder got on his back.
Okay. Want me to confirm?
Yes.
Nothing else, Your Honor.
Any redirect?
Yes, Your Honor.
All right, Mr. Theophilopoulos.
You saw the video, correct?
Correct.
And it's in evidence, right?
Correct.
Who starts moving towards who first when you're standing in the middle of the, whatever, what is that, a volcano you said?
I guess they call it a mosaic. We'll call it a mosaic. It's a volcano. It's the symbol of the flagland base.
Who moves first towards each other? Did you move first, or did Mr. Gaffney move first towards you?
John Gaffney absolutely moved first towards me, and that was after a line of masked men moved towards all of us with hundreds of gallons of water to pour on us.
On that video, and the jury will get it, but on that video, prior to you pushing the powder up, something happens. Did you notice it?
Yeah, well, he makes a sudden movement with his bucket, and yeah.
And then what happens?
Well, so he goes to make a movement. I remember I took the bag and I threw it at the ground, and then he made another movement and I threw it higher up, and I was actually shocked by how much of the powder came out of the bag because it was a lot bigger of a cloud than I thought, but that's what happened.
Thank you. Nothing further.
All right, you can go sit down with your attorney, please.
Thank you.
Will the defense have any other witnesses? The defense rest?
We do.
All right, can I have the attorneys approach the bench? Do y'all have any rebuttal witnesses? Who? And why?
For the intention of the fact that they got into on the direct examination of the defendant, and the fact that he showed him the video over and over again, and it was on him. And then they went back to the police station, finding that he's part of the supervisor, and he was trying to get him out of the charge.
All right, I'm going to permit you to do so. All right, State, do you have any rebuttal witnesses?
Yes, Your Honor. At this time, the state of Florida calls Officer Frost back to the stand.
All right, Officer Frost, please.
Officer Frost.
Officer Frost, I'm going to remind you that you are already under oath.
Yes, sir.
Ms. Mee?
Yes, Your Honor. Hi, Officer Frost.
Hi again.
I just have a few brief questions for you, and then we can hopefully be on our way. Officer Frost, you mentioned in your direct examination, as well as on cross-examination, I believe, that you viewed the live stream presented by Mr. Smith-Levin. Is that correct?
That is correct.
Okay. And how many times do you recall viewing that live stream with Mr. Smith-Levin?
Repeatedly. I don't really have a number, but I think it was multiple times.
Okay. And was he showing you that video?
I believe it was on my phone.
Okay. Did you, at that time, were you reviewing the entire video comprehensively, or were you only reviewing a snippet?
Snippets.
Okay. And you also mentioned that you ultimately spoke with your supervisor. Is that correct?
Yes.
Okay. And you indicated that at one point you reviewed the video comprehensively.
Correct.
I'm going to object. This was consistent. This is not
Overruled.
And at that point, did you make a decision on how to proceed?
I did.
Was that prior to transporting the defendant?
It was.
Okay. Who did you ultimately determine should be charged?
The defendant in this case.
Okay. And who is that?
Aaron Smith-Levin.
Okay. At any point, did you try to get the defendant out of a charge?
Not out of a charge, it was just if he qualified for different circumstances under APAD.
Okay. And can you tell the members of the jury what that means?
Yes, for certain minor crimes such as misdemeanor retail thefts, sometimes criminal mischief, trespassing, more so like petty offenses. If that's your first offense, typically you can qualify for a diversionary program. So APAD stands for Adult Pre-Arrest Diversion, which involves somebody cooperating with an investigation, and ultimately they would have to pay restitution if they damaged or stole something, or do community service in lieu of facing jail time.
And in having that conversation with Mr. Smith-Levin, were you just speculating at that time?
I was.
And then upon completion of your investigation, did you charge someone with a battery?
I did.
Okay. A moment to confer.
Yes.
Nothing further, Your Honor.
Any cross-examination?
Very briefly, Your Honor.
All right. And Mr. Perlman?
Yes, Your Honor. Afternoon again, officer.
Afternoon again.
So you did watch the video several times before going and speaking with the supervisor, correct?
Yes.
Okay. You watched it multiple times. You go to the supervisor. After speaking with the supervisor, you make the determination you're going to arrest Mr. Smith-Levin, correct?
Correct.
Okay. And then you were attempting at some point to get him into the APAD as opposed to formally arresting him. Is that correct?
Yes.
All right. You reached out to try and do that so you didn't have to make the formal arrest, right?
Correct.
Nothing further, Your Honor.
All right. Any redirect?
Yes, Your Honor. Officer, were you trying to get him into the APAD program, or were you just evaluating whether or not he would qualify?
Evaluating qualifications.
Nothing further, Your Honor.
Nope. Sorry.
All right. May this witness be excused?
Yes, Your Honor.
All right. You may be excused. Thank you.
Thank you, Your Honor.
All right. Do you have any further witnesses?
No, Your Honor. Stay rest.
All right. All the attorneys approach. What says the defense?
We renew our judgment of acquittal argument. Now it's a reasonable juror standard, still viewed in the light most favorable to the state in this situation. I would argue that based on the testimony of our witnesses, including the defendant himself, that a battery occurred against him, that he acted in self-defense. I would argue that there's sufficient evidence to establish that the state cannot establish the case of battery.
In addition to our prior argument, the defendant quite literally admitted to the battery on the stand. So, yeah.
This is for the jury to decide sufficient evidence has gone forward. I'm going to deny the judgment of acquittal. You all have 30 minutes for closing arguments. You have a closing and then you have a rebuttal if they close. Okay? All right. Thank you.
One question. If we could, I'm not sure when you intended to release the witnesses, if we can release them now.
Yeah, you can go ahead and release.
And then additionally, Mr. T.
It's okay.
Did show something that he intends to use in the closing argument, and the state may have objecting to the use of that.
What are you using?
It's that First Amendment. It's the language of the First Amendment. You actually saw it in the Tringali case. I don't know if you recall that one. It was actually a Scientology case where he was protesting.
I always get all the fun cases. Okay.
I have it over there. I can show it to your honor. He actually took it and said, no, we're not trying jury trial. This will be a bench trial.
All right. This is the deal. It's whether he was on public property or private property, whether he was exercising his fundamental right to protest or not, those are not defenses to a battery, because a battery can happen on public property and a battery can happen if you're exercising your fundamental right to protest. So you can argue all you want that he was protesting on the Constitution, yada, 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 but whatever it is you're going to use, you're not going to use. Okay? All right.
Do not use.
Do not. N-O-T. Because apparently either your hearing's going or I'm not clear enough for you.
I read those previously for trial and then during trial afterwards, and I'll leave it at that.
We're good.
I'll leave it at that.
So I can go release it really quick.
Yeah, go release him. Ladies and gentlemen in the audience, I'm going to advise you that we're getting ready to go into closing argument. If anybody wants to leave at this time, this is the time to leave. Nobody will be permitted to move or leave during the course of the closing argument. Yes, go ahead and open the front row.
So you move over, please, make some more room.
Ladies and gentlemen, both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument if the defendant does a closing argument. State, you may proceed.
Mr. Honor.
Mr. Lechner.
Please quote. Counsel. Members of the jury. You've seen the evidence. You've seen the videos, you've seen the pictures, you've heard the testimony. And it's exactly like my co-counsel, Ms. Smee, told you at the beginning of this trial. This defendant let his emotions get the best of him. On July 29th, 2025, even on the stand today,
Now, what's a battery? We all heard that during jury selection, that we've charged this defendant with battery. But now it's finally time for us to explain kind of what that is. Now, Judge Hessinger, she's going to tell you that the elements of battery are that this defendant actually and intentionally touched or struck John Gaffney against his will. Now, what's all that mean? Well, let's break it down. Actually and intentionally. Does that mean that you have to punch someone in the face to commit a battery? No, it doesn't. It means, and there's actually an instruction on this, that an intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. I mean, you heard it on the stand, members of the jury. You saw it on the video. There's not a question that when he did that with the powder, he intended for that to hit the victim. You saw pictures where it did hit the victim. You saw the video, multiple videos, where it enshrouds Mr. Gaffney. Members of the jury, we met the elements of battery. Now, some of you may say, well, it only touched his shirt. That's still a battery. If it's connected to you, such as clothes that you're wearing, that's a battery. Not only did it touch his shirt, his pants, his shoes, it touched his face as well. But, remember the jury, that's not all we brought you. Because we brought you statements from this defendant. Now those statements were told to you by Officer Frost, by Detective Beaver. Some of them were told to you by the defendant himself. Some of them that he could remember. Some of them that, he can't remember today. Those statements, secret weapon. Here you go. Members of the jury, this was intentional. This defendant got powder knowing what he would do. He walked up to that victim knowing what he would do. He threw that powder all over the victim knowing what he was doing. This wasn't an accident. This wasn't purposeful, or this was purposeful, intentional. What this wasn't is self-defense. I mean, are you kidding me? We all saw that video. No part of that video is self-defense. You can see on the video where Mr. Gaffney goes to the side. You can see Mr. Gaffney not walking directly towards Mr. Smith-Levin, but walking along that railing. Mr. Smith-Levin, he doesn't stay there. Someone that's acting in self-defense, someone that is so afraid of this water, doesn't walk up close to it. That's not what you do if you're scared. What you would say is, don't do that. Not, here you go. Mr. Jury, one of the items that Judge Hessinger is going to read to you, well, it's called weighing the evidence. Now, what's that mean? Well, essentially, as a jury, it's up to you to decide the credibility of all witnesses and evidence that you see today. And, defense, they made a line in their opening that I'd like to bring you back to. The video speaks for itself. Members of the jury, you don't have to believe a thing that happened today. If you don't want to. Because you have a video. But you have a video that you can watch. A video has no bias. A video doesn't forget. No, a video shows it exactly how it happens. But how can you weigh witness testimony today? Bless you. Did the witness seem to have an accurate memory? Is one of the things Judge Hessinger will read to you. And about every third, fourth question that I ask the defendant, he goes, I don't remember. I'm not sure. Maybe if you say so. He can tell you everything about what he was thinking on direct examination, But as soon as I get up here, he forgets exactly what happened. Sure, that's cold. That's called testifying so that he's not convicted. No. What else is on that thing called weighing the evidence? Was the witness honest and straightforward in answering questions? Well, I think we all know the answer to that question. Because on direct examination, it's a simple yes. There's a simple explanation. As soon as I get up here, I ask, were you standing in this spot? He goes, well, maybe if you take this into account. The jury, that both of defense witnesses, they're not straightforward with us. No, both of Miss Fullerton, she testified today to help her friend out. You can judge their credibility. But again, what's important? The video. I gave you two. In case you don't really know from that one angle, we gave you a second one. And yeah, we only showed that second one time today. But I encourage you to go watch both of them when you deliberate. Because you'll see that there's not a doubt in this case. Now, we only have to prove our case by a reasonable doubt. And we certainly did that, members of the jury. We certainly showed you Mr. Smith-Levin committed a battery on July 29th, 2025 on John Gaffney. Heck, he basically admitted to it on the stand. We also had to show you it wasn't in self-defense. And it clearly wasn't. Members of the jury, he doesn't have any power. Power's in your hands. As a jury, you are going to be the ones that find this defendant guilty. And what we've shown you today, it's not only enough. It's not just enough. It's more than enough. And I'll be the first to say, protesting? Fine. I encourage it. If someone wants to protest because it's something they believe in, they should. That's our right. As Judge Hessinger mentioned in jury selection, our founding fathers had rights in mind. And one of those was that First Amendment. So Mr. Smith-Levin, if he wants to protest, he's more than welcome to. But there's a fine line between protesting and committing battery. Just because you're a protester doesn't give you a license to commit crime. That's where he went too far. That's why he's guilty, members of the jury. He committed that battery. And we're confident that you'll come to the only verdict that the evidence supports and the only verdict that justice demands. A verdict holding this man responsible for battery. Thank you.
Will the defense be doing a closing argument?
Yes, Your Honor.
All right, Mr. Theophilopoulos.
I'm often asked, why does the state of Florida have the burden of proof in a criminal case? 100%. 100%. As you heard earlier this morning, we could have sat there and said nothing. But why is it that the state of Florida is responsible for meeting that burden, if they can, and they haven't in this case, beyond and to the exclusion of every reasonable doubt, including self-defense? I'm going to tell you why. King George III of England was a very controlling tyrant of his people. And when the colonies evolved in other areas, including British colonies in the United States, he started to lose control. The people were scared of his government. he was a tyrant. What did King George III do? King George III would take people from America, the United States, wasn't the United States at the time, a continent here, North America, ship them back to England, and they would have jury trials that were predetermined because he had his people on the jury. He had a 100% conviction rate. So in America, the people were scared of government as it grew. And when our founding fathers put the Constitution, the Declaration of Rights, everything together, they made sure there were safeguards that big government could not crush an individual. And one of those were the burden of proof 100% is on the government. Now, the state in this case has drawn a line in the sand. We drew chalk on the ground. A First Amendment pure right, freedom of expression. There is no dispute where they were at. They were permitted. It's public property, even though the appearance gives a person who wouldn't know better, that is the Scientologist property. Well, no, it isn't. The city of Clearwater, for some reason, we don't know why, has allowed them to build on the property, and the public use it as well. And when I go through the various testimony that you heard, there's a few things I want you to remember that will be in your jury instructions. And it's weighing the evidence. A few of these things is, did the witness seem to have an accurate memory? Matteo Mondaschi, was his memory accurate? No. There were moments of silence throughout my questioning of him. Who instructed you to go out there and pour the water? He didn't want to say it. Was the witness honest and straightforward in answering the attorney's questions? These are the jury instructions that you will hear. Well, in this exhibit I have up that was introduced, if you recall, right there, John Gaffney, and this is before he got the blue corn stalk or whatever it's called on him. He told you, he looked you in the eye and said, well, I never saw any writing out there. Well, there he is. So was he truthful to you when he said that? Absolutely not. That was an untruthful statement. He was out there, and for him to say he didn't observe any writing is a lie. If you see the water barrier, it is there so that they cannot erase the word cult. That's why that black water barrier was there. They needed so much water to get through that barrier, over 150 gallons plus the 5-gallon buckets. Did the witness have some interest in how the case should be decided? On July 29th, the Clearwater Police Department stood shoulder to shoulder with Scientology. Today, they sit shoulder to shoulder in the front row. Do the witnesses have some interest how the case should be decided? Shoulder to shoulder in the front row. Does the witness's testimony agree with the other testimony and other evidence in this case? Mr. Smith-Levin and Cheryl Fullerton, did their testimony mesh. Absolutely. They've been going out there a very, very long time. And they've been protesting. You know, it's like at the schoolyard during PE, physical education. There's always one big bully. Always one big bully. And that big bully picks on the little kid every single time. And it goes on for days, it goes on for weeks. Enough is enough. They don't have to pour water out there. And you know, again, were they honest and forthright? Well, they're damaging the property. Well, when I questioned Mr. Gaffney, when I questioned Mr. Mandashi, and I said, security, what are you there for? We're there to protect the people and the property. They're not there to clean up. Maintenance personnel with the flag crew is there to clean up. But they wanted the muscle. They wanted the men in black coats. And they got it. Their own picture they introduced into evidence of Mr. Gaffney. Their own picture. States 3C, evidence of the crime, right here. The state is asking you, forget about the water. It's just water. You use, for self-defense, equal force, not more. You don't pull a gun out if somebody's going to be spraying you with water. You use equal force. The powder. It's equal force. And it's remarkable how Officer Frost took the stand. What did he say? There's a sign up there. They can't go past, straight up top. They can't go past that sign. So where they were at was completely legal. Other times, he said, they admitted water was thrown on them. He agreed. Agreed. Mutual battery here. Well, they threw the water. It got on him, it's apparent. And he threw the powder. It was mutual combat, mutual battery. And then he also admitted when Mr. Perlman questioned him, yeah, throwing water on a person is a problem. If someone threw water on me, it would be a battery. So what exactly is going on here with Clearwater and Scientology? So Officer Frost, after viewing the video multiple times, determines now these are two kids in the playground. One threw water and one threw some dust. Let it go. But it gets worse. He's called for the supervisor. Higher up with Clearwater. And for some reason, the power of Scientology causes the supervisor to tell Officer Frost, no, you charge him with a battery. Well, what about the other battery? The water. That just disappears. That's how powerful Scientology is. There's a higher being in control here, according to them. If you don't have an interest, if you're not in cahoots, why are you sitting short? shoulder to shoulder in that front row, a show of force, cross them arms. The long arm of Scientology. Mr. Smith-Levin had no reason not to cooperate. Why? It's self-defense. The big bully got punched back in the nose just like the big bully for weeks and weeks and weeks was punching them in the nose. Mr. Gaffney, Mr. Mandashi, Mr. Mezensteff, they all wanted you to believe that this chalk was so damaging to the city's property. As you heard from Miss Fullerton, it goes away with water, with rain. One spray and you're done. So they're out there protesting, exercising the First Amendment. Their First Amendment, freedom of speech. I, Adam Smith-Levin, disagree with Scientology. Cult is what he calls it. And I'm going to protest. Well, Scientology doesn't appreciate a protest. They want to quell the protest. They want to end it. And the only way they can end a protest is by having somebody like my client, our client, arrested. This is wrong. This happens in third world countries, not America. This happens in Russia when you disagree with the higher ups. But this is America. And when you're on public property, you can speak your mind and you can protest. And you should be able to do that without the fear of arrest. How do we know, again, that Mr. Gaffney, he was called a victim in this case, he is hardly a victim. How do we know, furthermore, that he said, I didn't see the writing. Well, we saw the picture, he's out there. But even further, Mr. Mezensteff said, we saw the word cult a half hour earlier before dumping the water. And remember, he said they were in a group. They were in a group talking. How are you to believe Mr. Gaffney on that statement alone? When you look at the video, in this case, there's two videos the state introduced. One of them is from walking outside the doors of the Scientology building, and you'll see the army members carrying their armor and carrying their weapons. And then dumping that water. There's Aaron Smith-Levin, and you see it, and he goes on. If powder touching somebody is a battery, water being thrown on somebody is a battery. But there's an arrangement in Clearwater. And that arrangement favors Scientology.
Objective facts, not in evidence.
It's argumentative.
No, it's sustained. You have to argue facts.
Well, the facts are water is thrown on my client. Powder in return by my client is thrown on Mr. Gaffney. And for some reason, we can only imagine, my client is arrested. The big bully thinks he's going to win again today. He's not going to win again today. Collectively, you all are the most powerful group in Mr. Smith-Levin's life today. And you take it out of the hands of the government, the state of Florida. They don't always get it right. And today is a primary example of that. Detective Bieber's testimony. Let's touch on him. He admitted Mr. Aaron Levin Smith basically had nothing to hide. He waived his Miranda. Nope, don't need to remain silent. Nope, don't need a lawyer. I'll tell you everything you know. You guys have the video. I already showed it. I had nothing to hide. When you look at that video, second one, which is Mr. Smith-Levin's back to the screen, you're going to see the 3 Scientology security personnel. And then you see John Gaffney go off to his right, to Mr. Smith-Levin's left. He singles himself out, starts to come forward, and then Mr. Smith-Levin goes forward. Come on, what are you going to do? The big bully was trying to threaten him one last time. And the big bully got dusted. And he deserved it. You're also going to hear about reasonable doubt. Part of the instruction. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. It must be abiding. It must be strong. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if you do have a conviction, it is one which is not stable, but one which wavers and vacillates, I'm not sure, then the charge is not proved beyond every reasonable doubt, and you must find Mr. Levin Smith not guilty because that doubt is not reasonable. You are also going to get the most important jury instruction. Justifiable use of non-deadly force. It is, and this is a complete defense, it is a defense to the crime of battery if the actions of Aaron Smith-Levin constituted the justifiable use of non-deadly force. Non-deadly force means force not likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivia, minor, or moderate harm. Aaron Smith-Levin does not have the burden of proving that he was justified in using non-deadly force. Instead, for you to find Mr. Smith-Levin guilty, the state must prove, again, here we go, beyond a reasonable doubt, they have to prove that he was not justified in using that powder. Because powder is non-deadly force. Cornstarch. Have they proven that he wasn't justified beyond and to the exclusion of a reasonable doubt? Absolutely not. In fact, their own evidence shows they were committing batteries on Mr. Levin Smith. Mr. Smith-Levin, excuse me. In deciding, the law on the justifiable use of non-deadly force is as follows. Aaron Smith-Levin was justified in using non-deadly force against John Gaffney. Here's the kicker. And he had no duty to retreat if he reasonably believed that such conduct was necessary to defend himself against John Gaffney's imminent use of unlawful force. So when he walks up to him, he doesn't have to retreat when he splashes the water. And he has every right under this beautiful jury instruction to defend himself with the powder. He's using equal force with the force that Mr. Gaffney was applying. You'll have an opportunity to read this instruction, but it is the most powerful instruction you'll read today. They're all very important. but I strongly urge you to review that. At the end of the day, what are we left with? Well, we're left with an individual who is not guilty. He had every right to stop the big bully Scientology. He had every right to defend himself. Their view, obviously, is different. You can't throw water on somebody that's sitting on a sidewalk. It's battery, and they have a right to defend themselves. You can't throw water on an area that looks like it's the Scientologists, but it's not, because of whatever arrangement they have with the city of Clearwater.
Objection. Facts, not in evidence.
Overruled. They did talk about they got permission.
Whatever arrangement the city of Clearwater has with Scientology. And then you had, at the end of the day, at the moment, an unbiased officer, Officer Frost, who looked at everything and said, no. That alone is reasonable doubt. Officer Frost wasn't going to arrest anybody. It's mutual, kids play. But then, again, here we go. Higher ups, City of Clearwater, a supervisor brings the hammer down. You're going to arrest not both of them, but just one. The big bully thought he won again. But today we take the big bully down. And the only way is the only right verdict in this case. The justifiable use of non-deadly force is self-defense. People don't have to put up with others committing batteries on them. He stood up for his right to protest, for his First Amendment, freedom of speech. It's not guilty. Thank you.
State rebuttal?
Yes, Your Honor.
For the record, Ms. Me.
Thank you, Your Honor. May it please court, counsel, members of the jury, we're almost there. I'm the last one that's going to get up here and talk to you before the judge instructs you on the law. So I ask you just listen a little bit longer, and then off you go to deliberation. I want to touch on a few things that were just discussed on defense's closing argument. But quite frankly, members of the jury, this case is simple. It boils down to one thing and one thing only. This instruction, this element. As I stated on opening statement, and has been discussed from jury selection all throughout this trial, is that we as the state of Florida bear the burden in this case. And that's to prove all elements of the crime charged beyond a reasonable doubt. And members of the jury, the only element in this charge is right there. Aaron Smith-Levin actually and intentionally touched or struck John Gaffney against his will. One element. And members of the jury, we've proven that over and over and over again. Members of the jury, I submit to you that defense counsel got up here and talked to you about all these possibilities, all these things, all these conspiracy theories, for lack of a better term, about agreements between Clearwater and the Scientologists and the big bad bully of Scientology. Members of the jury, we started at the beginning of jury selection talking about Scientology is going to come up today. But you also agreed by sitting in these seats here today that you're going to follow the law. Members of the jury, what's the law? That was the law. If we have proven our case against Mr. Smith-Levin beyond a reasonable doubt, that you will find him guilty. And we did that. So all this talk is to distract you, to be quite frank. It's throwing everything at the wall to see what will stick. The concepts of constitutional rights to protest, the concepts of where things happen, property lines, drawings, this, that, and the other. Members of the jury, it's simple. What happened here was that, and we agreed, Mr. Smith-Levin was acting on his constitutional right. We can even agree to that. I don't even care. We agree. But what the problem is that he went too far. Like I said in the very beginning of my opening statement, he let his emotions get the best of him, and he committed a crime. And for that reason, he sits there guilty. I want to go through a few things that were brought up on defense's closing, including this point that Mr. Madashi sat here in silence and clearly his memory is not accurate, or actually he's hiding things. Members of the jury, what it comes down to is he said multiple times to defense counsel, I just don't remember who instructed me to do that. But quite frankly, what does it matter? It doesn't. Who cares? Distractions. That is all that is. Pointing to things so that you're like, oh, maybe that matters. No, it doesn't. Simple. Pointing to what I think is truly ironic is pointing to that his memory was inaccurate when he can't give you an answer, but instead, Mr. Lechner is asking Aaron Smith-Levin, seated right here, about this big event in his life, and all of a sudden he can't remember things, he can't get a straight answer, he wants to play games. His memory is accurate. If we're going to play that game, I think I know where it ends. Defense counsel wants to talk about who was truthful, pointing fingers that Mr. Gaffney clearly is not truthful. Again, members of the jury, you know who took the stand? The defendant. And you know what he couldn't do? Give a simple answer. Instead, he's talking in circles. He's saying things that make no sense. He will do anything to actually not answer a question that Mr. Lechner asked. There's this emphasis on the word cult. I wish I tallied the number of times that there was an emphasis on the word cult. Once again, what does it matter? The purpose for what Mr. Gaffney and the others were doing is irrelevant. What matters is what happened in the video you watched. What matters is the facts and the proof that they were simply washing away chalk. What matters is what this defendant does in response. There was a point made about the fact that the members of the Church of Scientology are sitting shoulder to shoulder. Members of the jury, I submit to you that this panel, this room, is packed. Are you kidding? Where they're seated means something? Distractions. That is all defense has in this case, is distractions. Where they're seated doesn't matter. They came in when they were allowed to come in, sat down, and are listening like everyone else in this room. Bullying. The big bad bully of the Church of Scientology. Members of the jury, I submit to you there's another bully in this room. And that's Mr. Smith-Levin. You heard his words on the video. You saw his demeanor to Mr. Lechner. The video speaks for itself. That's all I can say. He's the one poking. That's what defense wants you to say. Yeah, you're right, but you got the wrong person. Honestly, my favorite line was, the state doesn't always get it right. You're right. But you know what? We got it right this time. Because it was on video. You saw it. You saw the way he acts. You saw what he did. This concept of the mutual battery. We intentionally had Officer Frost come up here once again and clarify. Yeah, I made a statement of speculation upon reviewing a video that was shown to me by the defendant, who clearly has a reason for showing him that video. I specifically asked him, did you review that video comprehensively before you made a statement? And he said no. I then followed up and I said, when you ultimately reviewed that video comprehensively, was that with your supervisor? He said yes. I then asked him, okay, you reviewed that video comprehensively with your supervisor, and then is that when you made your decision? And he said yes. All he did was an investigation. He did what any other human would do. He made a quick statement, but then he thoroughly conducted his investigation and proceeded. Another distraction. Members of the jury, I just want to point out one more thing. Defense is hanging their hat on the fact that this is self-defense. All Mr. Smith-Levin did that day was act in self-defense. But members of the jury, right before I sit down, I'm going to play that video one more time because that's what this is. And in that video, you saw over and over again Mr. Gaffney with a bucket of water walk to the side of the steps with his head down, which was even a point made by defense. There's no interaction, nothing. Head down with a bucket where there's chalk on the ground, and he dumps the water at the ground. At no point is there a at Mr. Smith-Levin. Is there up in the air? Nothing. Down to the ground, at which point Mr. Smith-Levin walks in the way and then gets in his face and throws the powder at him, his secret weapon. Members of the jury, there is no self-defense even if you try and see it. There is a specific quote by defense counsel where he said, Mr. Gaffney singles Aaron Smith-Levin out, walks down the stairs, and throws water at him. That's not what happened. That's not even close to what happened. Members of the jury, you will watch the video one more time here, and then you will have all the time you need in deliberations to review that video again. Remember, all that matters is that we as the state have proven this case beyond a reasonable doubt. And I told you on opening statement that we would do just that, and we have.
Ready to party? Jamie.
I got you, by the way.
Let's get ready to party, baby. Come on, bring it. Bring it. Bring it. Oh, it's just gonna hit our water barrier, you losers. Yeah. Here you go.
I got everybody in it, by the way.
Yeah. Come on, bring it back.
Defense counsel said it, and I'll say it. Let's put a stop to the bully today. Find Mr. Smith-Levin guilty. Thank you.
All right. Can I have all council approach, and while they're doing so, two things are going to happen. I want y'all to stand up and stretch for a moment because I'm getting ready to read you jury instructions and you've been sitting around, so go ahead and stand up. And then also I'm going to advise everyone sitting out in the audience that I am about ready to read jury instructions, and so the deputy's going to secure the courtroom, which means no one's coming in and no one's leaving. So if you do not want to hear jury instructions, then this is your moment to leave. But once I start reading, then you will not be leaving the courtroom. So this is your time to do it.
One copy, but bring it back there. Do they all get copies?
Copies of what? The jury instructions? Yeah. I read them and then they'll bring one copy back.
Just one copy?
Mm-hmm. Yeah. Y'all didn't look at the verdict form, so I need you to look at the verdict form and make sure there's no objections. Okay. I know there's a few people that bring that up, but they got the burden of proof. So.
Well, that's why not guilty should be first. Thank you, Your Honor.
All right, last call for anybody who's leaving the courtroom. All right, deputy, is the courtroom secure?
Yes, Your Honor.
All right, thank you. All right, if y'all have a seat now. All right, ladies and gentlemen, I'm about ready to read you some jury instructions. The upside to it is a copy of the jury instructions will go back with you, so you do not need to take any notes on the jury instructions. I am required to read them all to you by law to make sure they are all read, but if you need to go back and reference something while you're deliberating, you'll have a copy of them. Courtroom secure?
Now the doors are secure.
Thank you. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on, whoops, I already read that to you. How about I go to the introduction to final instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Statement of the charge. Aaron Smith-Levin, the defendant in this case, has been accused of the crime of battery. Battery. To prove the crime of battery, the state must prove the following element beyond a reasonable doubt. Aaron Smith-Levin actually and intentionally touched or struck John Gaffney against his will. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, the object that is touched or struck must have an intimate connection with the person that it is to be regarded as part or as an extension of the person. Justifiable use of non-deadly force. It is a defense to the crime of battery if the actions of Aaron Smith-Levin constituted the justifiable use of non-deadly force. Non-deadly force means force not likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. Aaron Smith-Levin does not have the burden of proving that he was justified in using non-deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using non-deadly force. The law on justifiable use of non-deadly force is as follows. Aaron Smith-Levin was justified in using non-deadly force against John Gaffney and had no duty to retreat if he reasonably believed that such conduct was necessary to defend himself against John Gaffney's imminent use of unlawful force. In deciding whether Aaron Smith-Levin was justified in the use of non-deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of non-deadly force was necessary. Moreover, a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Aaron Smith-Levin and John Gaffney. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means that you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or testimony of any witness. Instruction on edited recording. Members of the jury, you viewed video recordings today. The court instructs you that the recordings have been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way you view and consider this evidence. Rule for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged in the information or not guilty. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. This verdict must be unanimous. That is, all of you must agree to the same verdict. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you, and it is as follows. Here's the verdict form. It says State of Florida versus Aaron Smith-Levin, has the case number. It says battery. We, the jury, find as follows as to the defendant in this case. Check only one. A, the defendant is guilty of battery as charged. B, the defendant is not guilty. And just put your check on the outside of A or B. So say we all. Foreperson of the jury signs it. The foreperson of the jury prints his or her name. And the foreperson of the jury dates it. And today is, I believe, March 3rd, 2025. 26, yes. Year got away from me, didn't it? In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the jurors return. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violations of these instructions I've given in this case, you must tell me by giving a note to the court deputy. Many of you have cell phones, tablets, laptops, or other electronic devices, including a smartwatch here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. As I told you earlier, the deputies will collect all of your electronic devices as you go in to deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law, and no juror has the right to violate the rules that we all share. If I can have all counsel approach the bench, please. State any objections to jury instructions as read. Defense any objections to jury instructions as read. Hey, I'm going to put in the clerk's jury instruction because Tracy had made a new one when her thing went in print, but Tracy forgot to add the check part. So I'm going to actually send back this one. Any objections by the state? Any objections by the defense? Okay, I want you all to go over and look at all the exhibits and make sure that every one of the exhibits that are supposed to go back there is there and ready to go back. Okay? Okay. All right, ladies and gentlemen, you're getting ready to go back to deliberate. What I'm going to tell you is that under the law in a county case, only 6 jurors deliberate on a case. But we choose 7 because we do not know on any given day, like today it's 7 o'clock already, if something might happen at home to a loved one that might get sick, or maybe one of you might get sick during the course of the trial, and for some reason we had to lose you during the course of the day. So we always pick an alternate to make sure that if something does happen, that alternate steps in. The alternate doesn't know that that person's an alternate, and you never know. But Ms. Lester, you are our alternate. And so I'm going to thank you for the time that you've given us today. We do appreciate it. It was very important to have you, but I am thankful that everybody's still here and healthy. Okay? Do you have anything in the back room?
Yes.
Okay, I'm going to have a deputy go back with you to get your stuff, and then let us know when you're bringing her out that way, and so that we can get them in the back. Okay?
Yes, ma'am.
All right, thank you. In the meantime, deputy, here is the jury, the verdict form, and a copy of the jury instructions to go back with the jurors, along with everybody has checked the evidence to make sure that everything's been done. Madam Clerk, I'm going to give you the jury instructions that I read today. This is the time we stare at each other while we wait for the alternate to get her stuff. I still think there's some snacks out there, so if y'all want to just take the snack bin with you back there.
We'll take it all.
Just take it all back there, I figure. And that's why it's out there. And I go to the grocery store, people think I'm a junk food addict. I'm like, no, just buying things for jurors. And if you need coffee, I think you all can help them get coffee.
Yes, sir.
I'm not sure they got the coffee machine still working. All right. And Are you ready? This time you will bring your notepads with you.
All right, ladies and gentlemen, go ahead and grab your pens. I'll have it with you. Take this.
If that's the alternates, I'll take that stuff.
There are the juries out of here in the court.
Okay. All right. Mr. Smith-Levin, your attorneys have done an excellent job for you today. All the attorneys in this case have done an excellent job on both sides. The case is now in the hands of the jury. They will make a determination as to whether you are guilty or not guilty. I will instruct that anybody who is staying for this verdict, you'll be waiting outside. I do not want to hear a deputy come back to tell me that people are being disruptive outside and have their phones out in each other's faces. So do not do that. If you come back in for the verdict, when that verdict is read, you are to keep that poker face. There is nobody is to make any type of response whatsoever. Does everybody understand that?
Yes.
All right. All right. You may be excused. Thank you.
Thank you, Your Honor.
Your Honor, the juries are present and advised that they have come to a
Verdict?
verdict. Yes, Your Honor.
And Jessica Cassell, are you the foreperson? Yes. If you'll give the verdict to the deputy, and everybody can be seated, please. Madam Clerk, can you please publish the verdict?
State of Florida versus Aaron Smith-Levin. We, the jury, find as follows: as the defendant in this case, the defendant is not guilty. So we say all. Foreperson of the jury, Jessica Cassell.
All right, thank you. Does anybody want the jury polled? All right. All right, ladies and gentlemen, I have one more instruction to give you, and that is that you do not have to discuss your jury services or your deliberations with anyone. However, you do have a right to discuss it with anyone that you want to, but if you don't want to, the only way that you have to is if you have a court order. So everybody understand that? You can talk about it all you want, but you don't have to if you don't want to. You may have somebody want to reach out to you to talk to you about it, and if you are not interested, you say no. Okay? All right. I'm going to thank you with a certificate of our appreciation. Deputies, I'm going to have you take the jurors out that way, please.
Yes, sir.
All right, thank you.
Folks, follow me, please. Mind me to step over there, man. Kind of jurors out of the hearing of the court.
All right, Mr. Smith-Levin, the state has found you not guilty with this on this case, so you may go hence without day. That means you're free to leave on this case. We're going to now, we have a pretrial set on your other case, which is case number 25-15304-MM, and we're going to go ahead and get that set for trial.
Thank you, Your Honor.
Hold on a second. The computer's getting tired. We're going to need to do hand notice on this case, Madam Clerk. I have April 14th.
I can make April 14th work, Your Honor.
All right, Mr. Perlman?
I I believe so, Your Honor. We'll decide if I'm going to be retained on. I think I will be, so I'll figure out a way to make that one work.
All right, trial will be on April 14th at 8:30. Motion in limine, trial conference, pretrial conference will be the Friday before, which will be on April 10th at 10:30. Mandatory appearance for both the motion in limine trial conference and the trial, which will be on April 14th. I've already gone through everything with you before, so you know the routine. Mr. Smith-Levin will go through motions in limine, and we'll do jury instructions, and we'll go from there. All right, Madam Clerk will give you a hand notice, and then we'll confirm your address.
Yes, Your Honor.
You want him to read his address in, Your Honor?
As soon as Madam Clerk gets finished doing the hand notice.
You can tell me.
All right, go ahead.
120 South Glenwood Avenue, Clearwater, Florida, 33755.
3755? Yes.
All right, do you have that?
Yes, Your Honor.
All right, everybody clear the courtroom, please. Actually, I take that back. Time out. I want everybody from the Church of Scientology and the Clearwater Police Department to leave first. Everybody else stays. And then after they have cleared out of the building, then the rest of you can leave. All right, State, you can leave. Deputies, you can let everybody else in the courtroom leave in 10 minutes.
Yes, Your Honor.
Okay, thank you. Madam Clerk, you need anything? You're free to leave.
Thank you.
Mm-hmm.
Thank you, Your Honor.
Mm-hmm.